Item number 2. This is 4, 5, 6, 7, 8. For hearing, item number 9 and 10.
9 and 10, my lord, I am appearing for the petitioner, ma'am. Okay. My lord, it is that selection. May I start, my lord? Well, it is that selection process, my lord. Almost I have concluded, my lord. Your lordship kindly consider the Abhishek Sharma's case, my lord, WPO 1386 of 2023. Ganesh Tiwari, my lord, hearing my lord, submission, I have concluded, my lord. Abhishek Sharma almost concluded. One aspect, my lord, kindly allow me to place. My lord, your lordship kindly consider on the last occasion, my lord, I indicated that the Coal India Limited, my lord, in their affidavit said that there are 19 questions in respect of which the agency awarded mark to all candidates whether they have attempted it or not. And these 19 questions are out of syllabus question, since, my lord, they related to events of 2015 or beyond. Now, my lord, I demonstrated that there are 26 other questions which are of events of 2015 or beyond. Although those questions, my lord, were not deleted or marks were not awarded to all. Therefore, there is a discrepancy, my lord, adopted by the agency. Now, my lord, in my, I have, my lord, shown all these 26 questions, my lord, from the writ petition. And in the affidavit in reply to the report filed by the CIL, my lord, from page 44 onwards, my lord, there is a list of these 26 questions, my lord, which are of events of 2015 or beyond. Now, my lord, I shall show, my lord, that your lordship kindly consider my affidavit in reply, page 56, my lord. 56 of my affidavit in reply. My lord, kindly see the name of the deponent was Sri Chinmayananda Gupta. He was the chief manager. Now, the present opposition or the report filed by the CIL was also filed by this gentleman. Now, my lord, I shall rely 2 paragraphs. Now, this is, my lord, in connection with at page 56, my lord, your lordship will find Amit Kumar Sinha, one of the candidates. He was, my lord, challenged the same selection process. However, my lord, later, my lord, I do not know what about this writ petition. Perhaps, my lord, it was withdrawn, or but this affidavit, my lord, was filed in connection with Amit Kumar Sinha's writ petition. My lord, your lordship kindly consider why I am placing this. My lord, the agency, my lord, decided that they will award 19 marks to all candidates. My lord, your lordship will find from this affidavit that the Coal India was in complete dark about this decision, my lord. This was affirmed on 29 September 2022. That is subsequent to all the process. Promotion was made on 21st February 2022. Then 12th August 2022, the final answer key was uploaded, and your lordship will find this affidavit was affirmed on a subsequent date, that is 29 September 2022. Your lordship will find from page 70. Now, my lord, your lordship kindly consider page 5, page 60, my lord. Internal page 5, page 60, my lord. My lord, the last paragraph, my lord, of Roman paragraph 11. The sentence starts with in the welfare. Yeah. In the welfare and personal discipline, 349 candidates have been provisionally shortlisted for interview based on the scores of CBT. Against 111 vacancies, petitioner submitted an email on 23rd of November 2021, filed writ petition on 26th of November 2021 before the Honorable High Court. In the email representation dated 23rd of November 2011 addressed to the chairman CIL, he has alleged that candidates did not receive any response from CIL recruitment team of the objections, and further alleged that so many questions were out of syllabus and most of the questions have wrong and confusing answer, which is not correct. And thus same is denied in toto. Therefore, on the date when the CIL affirmed this affidavit, they did not have any knowledge what the agency did. So they denied it. And Coal India, my lord, kindly consider is the employer. The agency was not the employer.
Yes.
Now, my lord, my learned senior friend, Mr. Roy, appearing for the CIL on the day when, my lord, he was started his making his submission in connection with Abhishek, in connection with Ganesh Tiwari's case, my lord, handed over one admit card of a candidate. My lord, I have once again, my lord, handing it over. My lord, this is, my lord, an admit card, my lord. আপনার কাছে আছে না? আচ্ছা নিয়ে নিন, প্রদীপ তো দিয়েছেন। মানে this is an admit card issued by the Coal India Limited. My lord, kindly consider the heading of this admit. It was issued by the Coal India Limited in respect of one of the candidates. My lord, kindly turn to page, second page, clause 4 in the middle. My lord, each question will carry 1 mark and there is no penalty for wrong answer. No marks will be awarded for unattempted question. My lord, kindly consider it. This was the directive of the CIL. Therefore, my lord, in the admit card, my lord, it was categorically stated that they will not award any mark for unattempted question. However, my lord, this decision, my lord, taken by the agency to award mark to all candidates, irrespective of the fact that whether they have attempted it or not, is contrary to this direction issued by CIL.
Yes.
Therefore, my lord, in order to sum up, my lord, there are 4 glaring illegalities, my lord.
Hmm.
My lord, the first illegality is that before the Nagpur bench, Bombay High Court, my lord, they submitted an application wherein, my lord, a timeline was given. I will say, my lord, this is an undertaking given by before a court of law, and this will come within the purview of Section 2B of the Contempt of Court Act. Although, my lord, that is a subject matter of before that court. My lord, your lordship knows, my lord, violation, willful or deliberate violation of any order or undertaking, then it will come under Section 2B of the Contempt of Court Act. This was an undertaking before that court that this timeline will be followed. And the timeline says that after receiving the last objection, within 10 days therefrom, my lord, they will upload the final answer keys, which has not been done. This is the first procedural impropriety. My lord, the second violation is, my lord, that Coal India, my lord, not Coal India, my lord, I will say the agency and Coal India supported it, had adopted a double standard or a pick and choose theory. Why I am saying this, my lord? Because, my lord, in their affidavit, my lord, they have said that 19 questions were out of syllabus on the ground, that all those are of events of 2015 or beyond. Then why they, my lord, allowed the other 26 questions which were pointed out? The same standard should have been considered that these 26 questions are of 2015 or beyond. Therefore, my lord, those questions were also should have been deleted. That has not been done.
No, I didn't get this.
My lord, there are 19 questions in respect of which the agency said we will award marks to all candidates on the ground that these are
Out of syllabus.
Out of syllabus because these are question of events of 2015 or beyond. Some are of 2018, some are of 2019. But I have demonstrated, my lord, from the writ petition,
There are other
there are
questions also.
26 other questions, my lord, which are of events of 2020, 2021.
All right.
So this is, my lord, a double standard adopted by the agency. Or I will say, my lord, a pick and choose policy, my lord.
Hmm.
Then, my lord, this decision, my lord, to award 19 question to all candidates, my lord, those who had not attempted it, is a clear violation of the directive, my lord, contained in the admit card issued by the CIL.
Hmm.
This is another, my lord, illegality. Now, my lord, the principal ground or principal question is that this decision, my lord, to award marks to all candidates
Hmm.
on any ground, maybe it is disputed, maybe, my lord, the answer key may be wrong or out of syllabus, whether this decision was taken prior to the selection process. Because, my lord, your lordship knows, my lord, as it has been fallen from your lordship, that the game rule of the game cannot be changed midway or after the game is over. So this settled proposition has been squarely violated if the Coal India failed to show that, my lord, this decision was taken afterwards. They must show by way of document or contemporaneous records that this decision was taken prior to the selection process. In the affidavit, my lord, they are completely silent on this point.
Yes.
Now, my lord, the fourth issue is, my lord, that it appears from the other affidavit, Amit Kumar Sinha's case, that Coal India was kept in complete dark about all decisions because they said there is no question. We are denying this. Therefore, my lord, the agency unilaterally took this decision. This is also, my lord, the agency cannot, my lord, keep an employer in dark.
Hmm. Yes.
Now, my lord, my last respectful submission before your lordship is that, my lord, in a competitive examination, my lord, a candidate who attempted a particular question and who had not attempted a particular question, my lord, are two different classes. Now, my lord, the Coal India or the agency, my lord, treated unequals equally, which is, my lord, in my respectful submission, is a gross violation of Articles 14 and 16. Article 16 is a 16 one is a facet of Article 14. Equal opportunity, my lord, the fairness is the sine qua non of Article 14 and 16. This fairness is missing from the entire selection process, and they considered unequals equally.
Yes.
Therefore, my lord, this vitiates the entire selection process.
Hmm. Hmm.
Now, my lord, your lordship knows, my lord, the well-known judgment of the Honorable Supreme Court in Tata Cellular's case, my lord, the scope of judicial review in respect of administrative decision. My lord, the Supreme Court says, my lord, the scope of judicial review is limited. But, my lord, if the court finds that there is an illegality or irrationality or procedural impropriety, the court has every power to quash any administrative decision. Your lordship will find, my lord, from the entire chain of events, that this entire selection process suffers some illegality and procedural impropriety, my lord. Therefore, my lord, this selection process should be quashed. But these are my respective submissions.
Your Lordship, I am led by Mr. Pradeep Rai. Yeah, perhaps he's stuck in another court. If your lordship will give another date, we'll respond on this date.
Very difficult for your learned friend.
My lord, before summer vacation, my lord, I will only.
No, your lordship,
request
this
for-
matter
one week is
has
there.
a Midas touch. The last one is sitting in the Legislative Assembly. My learned friend will be. But your lordship, I'll tell the difficulty. Your lordship, this matter, I should not say it's not their fault. The matter was heard on 4th. I am only briefed in this matter and I was not there. It was heard when I was not there. I actually cannot make submissions on this. I have heard what my learned friend has made submissions today, but I'm completely unaware of what was submitted in my matter. Lordship, the Ganesh Tiwari, the first matter, Mr. Rai was supposed to argue. The second one, I was supposed to. So I would only humbly pray that Mr. Rai is allowed to start the submissions in that Ganesh Tiwari matter.
See, next week is the last week prior to the vacation.
Yes, your lordship.
And I'm not keeping any hearing matter on that week. So it has to spill over after the vacation and it becomes a question mark.
I know, your lordship. I also don't want to
Lord,
put
this
that.
is, my lord,
Your lordship, my learned friend has
I beseech
completed
your
submission.
lordship, my lord. Then, my lord, everything will, my lord, the entire effort of not me, my lord. So far, my lord, Mr. Rai is concerned. He also started. Now, in this situation, my lord, it is very difficult, my lord, to.
Really difficult.
I-
What can be done?
Your lordship, I cannot ask for a Passover also. That is the
No Passover
difficulty.
in
That is the
business
whole
that-
difficulties. If Mr. Rai,
Every mark has parted, my lord.
The moment the determination changes, the part had
Yes,
goes.
I know.
What y'all can do is,
My lord,
in case the bench changes, if not, then everything is all right. But in case it changes, then you have to apply before the chief for getting it assigned because the matter was heard substantially by this bench. This much I can say.
my lord, may I request one thing, my lord? Your lordship, kindly consider. My lord, can it be fixed on Monday? Because I
Which
think
Monday?
next Monday.
Next Monday, last week prior to the vacation, I'll give all trust upon the motions and not hearings. Let us see what happens. এই দুটোকে একটু স্টেপল করবেন তো এই দুটোকে স্টেপল করে এর সাথে লাগবেন learned advocate representing the petitioner conclude submission. Stop. Learned advocate representing the respondents seeks time for starting argument. Released on 10th of June. We are reopening on
Your
the 8th. I keep it on the 10th.
Your lordship. Very well, your lordship. 10th is fine.
The last week also, my lord, time was taken on the ground of Mr. Rai. Today also, my lord. Now,
I
the
know, your
entire
lordship.
thing, my lord, I do not know very well. Grateful, my lord, extremely grateful.
Alright, item number 1, I appear for the petitioner. That pursuant to your lordship's direction, that the copy of the notice has been served. Now the difficulties, as the state is not appearing, but good news is that the petition may not be, well, we may not move this petition because the relief has already been granted. They have been released.
All?
Only 10:15 they will be released today by 4.
All right. So your
May I
purpose
come on
is
Monday?
served. Your purpose is served.
Purpose is served. May I come on Monday and withdraw the petition?
All right. I'll make it only not today.
Only not today. Sombar thakuk. I'll withdraw the petition.
Next one also.
No, the next one I have some argument. But two, I have sent notices to the office of the GP pursuant to your lordship's request and to the director of health service. But here, I wish to file a short supplementary affidavit. But kindly have a look to the supplementary affidavit once, how your lordship's order passed in one matter regarding this health assistant female.
Hmm.
Kindly takes up the supplementary affidavit, your lordship's order. Starting from page 7. Mursalina Khatun.
Please paginate it.
Kindly, I'll take only 1 second. Kindly takes up page 7.
Did you pay the court fees for all? No.
But court fee has not been paid by only I have
One.
paid one. I'll pay by today itself, pursuant to your lordship's order, which I have done.
Hmm.
But the interesting part is at page 7 and 8. Kindly have a look to your lordship's order,
Yes.
8.
Huh?
Paragraph 9.
Hmm.
On perusal of the document annexed to this writ petition, it appears that the Director of Health Service, after considering the circular date 29th of January 2024, passed so and so, transferred so and so. Then the Director of Health Service accepted the plight of the health assistant on being posted at districts far away from their home districts and pass order of transfer, despite observing that there may be huge discrepancy. Then the act of the director in allowing the transfer without completion of 3 years of uninterrupted and satisfactory service implies that the circular dated 29 January 2024 is primarily directory in nature. Then, accordingly, it is special disposed of directing the health to consider. This order was considered by the health the director. Kindly turns to the next page. 10. 11 and 12 are the operative part.
Hmm. But are we looking at this petition?
No, not this petition. But your lordship is constantly passing this order. But this Mursalina Khatun
Hmm.
approach your lordship. My lord directed that paragraph 11
Hmm.
that this is the circular is primarily a directory in nature.
But this here he has mentioned that he would persist with the
Exactly.
29th of January's order.
Yes. Which my lord has
At
clarified.
the same time, it is assured that the department would consider as per clause 234 of the said order.
Same is 3 years.
Hmm.
But when my lord has specifically mentioned in my lord's
See,
order,
in the other matter also, the concern of the court was the non-availability of relievers.
yes,
If reliever is available, possibly they will
there nothing
accommodate.
has been spelled out because 29th January's
So,
order.
why are we going to Mursalina Khatun now?
Because
It is,
the moment your lordship will be passing this order,
uh,
which my lord is constantly passing in Mursalina Khatun's order,
uh,
they will come up with this reasoned order by rejecting the case of the petitioner.
in the other matter, item number 1, see, the same order was passed.
No,
What?
but it was passed earlier. This order was they are from Ranu Hajra's group.
All right.
They
That
are
means-
within 156 who have been transferred.
All right.
So my lord is constantly taking up their example.
Hmm. Yes. But then what is important is reliever.
No, here there is no question of reliever. He has rejected the case of the petitioner, mentioning that
3 years.
yes, 3 years is the embargo, which my lord has clarified. If the High Court's order is being interpreted by the department like this, I leave it to your lordship.
Yes, but then let the respondents come. Otherwise,
Because
nothing can
they
be
have
done.
been served, they have received
It's
it.
all right. Please come.
Fix it on Monday or Tuesday.
Supplementary affidavit on behalf of the petitioners. filed in court today is taken on record. Stop. Let copy of the same be served upon the respondents.
I have served, my lord.
Supplementary.
Yes, with the supplementary.
আচ্ছা তাহলে ওটা বাদ দিয়ে দিন। None for the respondents. Let further notice be issued. Released on 8th of June.
8th of June.
Service is there. Acha,
In the meantime, may I
deficit court fees.
deficit court fee I'll pay. But in the meantime, my lord, may I get some protection?
What
on that?
type of
Because-
protection?
Because my lord, constantly the director is passing the other orders, my lord, by rejecting.
What type of protection can be
But
given your man? No
this-
order
this-
has been passed.
No, not in this matter.
Then
But the observation of the director is, my lord,
let the authority come.
very.
Yes, next.
I'm extremely sorry, my lord. In spite
Mm.
of my best efforts, I couldn't.
What can be done? I am there in the appellate side.
My duty to say sorry.
No, nothing. You were busy in some other court. It's all right.
I asked because.
Whatever. Yes, item 3.
Yes, item 3 and 4.
Lord, I am for the respondent, private respondent in item number 3 and for, I am for the writ petitioner in item number 3 and in the item number 4 I am for the private respondent. Now the crux of dispute is, my lord, selection process of ASHA worker in the
It has
district.
been released.
Yes, my lord, because my lord, we filed it under the head mentioning it as panchayat matter.
Yes.
So
Asha will go to Panchayat.
Asha will go to panchayat, but we filed it in education. Thereafter, my lord,
Education.
that is our fault. We
Huh.
have to admit it, my lord. My fault. I have to admit before your lordship. I must be candid before your lordship. Now thereafter, my lord, we on our request matter was released and we get it assigned so that both the matters, because both the matters are relating to the same selection process.
Is it Asha?
Asha, Asha, yes, my lord, Asha.
It should have gone to the group 5 bench. Why?
But my lord, it is an assigned matter. Both the matters are assigned, and my lord, because when it is assigned, my lord, then my lord, I would like to request your lordship to take up the matter.
Yes, if it is assigned, I do not have any other option but to take it up, or else I have to release it. What is it?
But,
What
my
is
lord,
it?
the case of the writ petitioner in respondent number at item number 4 is, my lord, that he is in serial number 2 of the selection list, and my case is, my lord, I am in serial number 3 of the selection list. Now, my lord, we have already filed an application in their writ petition for addition of party that is pending. There was a long back direction for exchange of affidavits, but despite such direction, they did not use any affidavit. Now, my lord, their specific case is, my lord, their specific case is, my lord, that the person who was appointed and who was selected.
Just wait. The assignment is not by name. The WPA number be heard along with such and such by the honorable bench having determination to take up item 12. Right, WPA 12. WPA 12 is
My matter.
your matter. How have you described it? Which group have you described? Classification list?
Classification list 12 এর লিস্টটা দেখো, এটার ফার্স্ট yes, status. If I am not wrong, yeah, it has been mentioned as one.
Yes, you mentioned at group 6. But then Asha matters are not taken up by the group 6 bench. It is the Panchayat bench taking up Asha matters.
If it's
And-
specially assigned, then my lord has determination. my
It's not specially assigned. It's assigned to the bench having determination. So bench having determination, Asha is to be heard by group 5 bench.
But I'll make end of it. Only thing is that I have been terminated from my service.
I am not going to the merits.
Bow
তো
down.
আসুন তো। এখানে লিখেছে গ্রুপ 6 কিন্তু বলছে মুখে আশা is always taken up by group 5 bench. You please get it clarified from the chief's office. ঠিক আছে? This will not be a group 5 matter. Yes. আশা চিফের কাছে অফিসের নোটিফিকেশন আছে, আশা will be group 5 matter. আর এটা তো বাই নেম নয়, এটা বাই নেম নয়, it's bench having determination. If bench having determination, panchayat matter will একটুখানি
No, no, 3 and 4.
জেনে নেবেন। নট টুডে,
আচ্ছা।
হ্যাঁ
এই
আফটার ভেকেশন করে দিই,
হ্যাঁ।
যদি দেখে নেন যে আমাদের নেই তাহলে ছেড়ে দেবেন। অর্ডার লাগবে কি, এটা প্লেস হলো কি করে আমার কাছে যদি আমার নাম না থাকে? কে বললো? মানে আপনি দেখুন, আপনি চিফের অফিস থেকে খোঁজ নিন।
We will keep it on any day, my lord. We can come back, and if my lord deems fit that my lord has determined, my lord will take it up.
I am confirmed Asha matters are taken up by group 5 bench.
I bow down to.
I have taken up thousands of matters Asha in group 5.
Oh, my lord, I bow down.
Nothing, only not today. Let it be clarified first.
I'm grateful.
Item number 6. Item number 6 was a time for the petitioner.
Yes.
My lord, petitioner was appointed on a compassionate ground on the death of her husband. Husband died in 2009. Petitioner got appointment in 2015. Retired in the January 2025. My lord, she had a service tenure of 9 years, 6 months, 9 days. My lord, in the pension order, it has been said that pension is nil because 10 years not completed. If your lordship kindly comes to page
Show me the provision under which it can be condoned.
My lord, rule 36 of the DCRB rules.
Please show. Yes, rule 36.
36.
Hmm.
My lord, your lordship has also has several judgment that 6
That is in the education matters.
matters, my lord.
But
It is-
whether this will be applicable in
there
respect
is
of,
rule 36, my lord.
yes, rule 36.
DCRB rules. Correct.
What you want? Book?
No, my lord, your
Hmm. Have you prayed for condonation of short?
yes.
Page 23.
Yes, my lord.
Please come.
And my lord, page 22, if your lordship kindly sees, pension nil.
No, that's all right. The petitioner is a retired employee of the Director of Animal Husbandry and Veterinary Services, West Bengal. Comma, Animal Resource Development. No, where were you serving?
My lord, under the Directorate of Animal Resource and Veterinary.
Directorate of Animal Resource.
Veterinary and Veterinary Service. Under the Directorate.
Directorate of Animal Resources and Animal Health. Animal Resources and Animal Health. Respondent number 4. Checkup.
Yes, I'm checking the appointment. My lord, it is Directorate of Animal Resources and Animal Health.
Directorate of Animal Resources and Animal Health, comma, Government of West Bengal. Stop. He retired after serving 9 years, 6 months, and 9 days. Stop. In view of shortfall in her qualifying service period of 10 years, qualifying pensionable service period of 10 years, comma, she has been denied pension. Stop. The petitioner is aggrieved by the same. Stop. Clause 36 of the death cum retirement benefit. আচ্ছা তার আগে West Bengal Service bracket open death cum retirement benefit. rules, 1971 has been relied upon, which mentions that upon any condition which it may think fit to impose, the government may condone a deficiency of 6 months in the qualifying service period of a government servant. Stop paragraph. It has been submitted that the petitioner made an application seeking condonation of the shortfall in the pensionable service period, and the same is pending consideration till date. Stop. The petitioner prays for consideration of her representation. Stop paragraph. None appears on behalf of the respondents. Stop. Affidavit of service is on record. Stop paragraph. As it appears that the petitioner's prayer seeking condonation of her pensionable service period in accordance with clause 36, rule 36 of the aforesaid rules is pending consideration at the end of the respondent authorities, accordingly, the instant writ petition stands disposed of by directing the
My lord, it can be respondent number 7 because respondent number 7 has issued that pension is nil.
senior accounts officer / PC hyphen Roman 2 being the respondent number 7 herein, to take into consideration the petitioner's prayer seeking condonation of her pensionable service period in line with the DCRB rules and pass a reasoned order in the matter. Steps shall be taken in the matter at the earliest, but positively within a period of 8 weeks from the date of communication of this order. If the prayer of the petitioner is allowed, then necessary consequential steps for releasing pension shall be taken without any further delay. Learned advocate for the petitioner is directed to forward a copy of the subject representation along with all other supporting documents to the aforesaid respondent at the time of communicating the order of the court. Disposed.
My lord, service may be kept.
Yes, yes.
But in this matter, I am for the petition. But here, my lord, petitioner is an employee of Indian Bank. My lord, 2022, petitioner has participated in an examination conducted by the IBPS, who is the autonomous body conducting the examination for recruitment of banking services. My lord, petitioner has selected ultimately, as per rank wise, petitioner has appointed as a clerk of Indian Bank. 2022. Subsequently, my lord, petitioner participated in the departmental examination and promoted as assistant manager of that bank. In 2025, petitioner further appeared in the IBPS examination. At that time, my lord, in the month of October 2025, petitioner received a notice from the IBPS authority, which is the independent body, that petitioner has conducted criminal personation, that petitioner ID is matching another 2 candidates' ID. Criminal personation. Petitioner's ID is matching another 2 candidates. Petitioner has been called for issued a show cause. Petitioner replied thereto. Ultimately, in the month of January, they have issued some punishment. IBPS authority issued some punishment against the petitioner. That petitioner is debarring to appear in further examination conducted by the IBPS authority, and another 2 clause. But what happened in the meantime, in the month of November, the bank, Indian Bank, who is my present employer, issued a suspension notice. My lord, kindly see the suspension notice once, page 42, which is impugned before your lords. My lord, kindly suspension, page 42. My lord, page 30. My lord. Kindly, pardon.
Yes.
my lord, I am reading, my lord, it is 24th of November 2025. In view of the grievous nature of allegations leveled against you, I am placing you under suspension with immediate effect under Regulation 12 of the Indian Bank Officer Employees Discipline and Appeal Regulation 1976 as amended from time to time. Pending further action be initiated against you during the period of suspension, you will be entitled.
Then what
Appeal.
happened?
My lord, what happened, my lord? Kindly see the rule, kindly see the regulation once, my lord.
Hmm.
Regulation 12, my lord, which is as page 42.
Hmm.
An officer, may I read? My lord? An officer employee may be placed under suspension by the competent authority where a disciplinary proceeding against him is contemplated or is pending. Where second B, where a case against him in respect of a criminal offence is under investigation, inquiry or trial. My lord, now my lord, kind to Regulation 5, which is at page number
36.
36. Who is the authority? My lord, the managing director or any other authority empowered by him by general or special order may be instituted or direct the disciplinary authority to institute disciplinary proceeding against in officer employee of the bank. A disciplinary authority may be himself institute disciplinary proceeding. A disciplinary authority such punishment. Now, my lord, my contention before your lordship is, my lord, there is no, my lord, there is no disciplinary proceeding has been initiated against me by the bank, who is my employer. Now, how this suspension order has been issued by the bank? This is the sole law point before your lordship. My lord, bank has to, my lord, IBPS is an independent body, is an autonomous body. Who conducted disciplinary? I have no nexus with the IBPS, so that my bank is my present employer. Bank has to initiate as per Regulation 12.
All right.
Bank has to proceed.
Contemplating disciplinary proceeding against him
Lots of disciplinary proceeding, the charges has been issued against him admittedly.
already?
Yes, already issued.
Yes.
And the proceeding is undergoing on, he will get an opportunity to go there. One. Second, your lordship, impersonation is admitted. He was the guilty of impersonation. Impersonation order passed by the IBPS till date has not been challenged. Rather, in the proceedings before the IBPS, he has admitted, yes, I have appeared earlier in 2 examinations on representing other 2 individuals, though I am not, but my pictures were there. I am having the photographs of that. IBPS, I am also appearing on behalf of the IBPS. Kindly see the conduct of the petitioner. When he has committed impersonation before in the competitive examination, your lordship, first he is representing himself as a Pankaj Kumar.
Pankaj Kumar.
Yes.
What do? You go and appear in by taking somebody else's name.
Thereafter, he
That is
representing.
an allegation.
Second time.
What do you do?
Well, that is an allegation. But
I understand. But how come your photographs get
Yes, second time. Your lordship, second time he appeared as Rajiv Meena.
Well, photographs is matching, but different is. But I am only.
And third time he appeared himself, become successful.
There is.
and these photographs are taken on the date of the interview or
Yes,
the
his biometric has been matched. All 3
Biometric?
biometrics has been matched. Not on the basis of photographs. Biometrics also matched. Thereafter, IBPS debarred him from appearing any examination, and there was a clause in the IBPS publication. And if you become guilty of impersonation, this guilty will be communicated to the bank where you have been impersoned.
No, that I understand. But the other 2 candidates whom he impersonated,
Yes.
did they get a job?
No.
They didn't get a job.
No.
But this
Nothing.
time he sat for himself and he got a job. What is his real name?
He-
Aditya Kumar Upadhyay.
Yes. 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 He admitted that I have appeared. He admitted I have appeared.
I am denying.
I
all the
ignore your
allegation.
lordship principle of natural justice.
Sir, what is the challenge in the writ petition?
Challenging, my lord, since my lord provides, my lord,
A
provides
disciplinary proceeding is already pending against you.
nothing.
What nothing? He says.
The charges have been
My lord,
framed.
charge
He is
is
in
framed
receipt of
when
charge.
the suspension notice has been issued. There is no, my lord, as
It
per
is in
Page 49.
contemplation.
Page 49. Charges has been
Sir, please come.
page 49.
my lord, give me, my lord, I am contesting the charge. Kindly direct the authority to conclude the, my lord, proceeding within the.
Why did you file the writ petition?
My lord, I have challenged that, my lord, there is no, my lord, what happened, my lord, there is no opportunity of so cause, right? There is no
That is something else. That is, you challenge the disciplinary proceeding is a different thing. You challenge the suspension order.
Disciplinary proceeding, my lord, entire proceeding I have said, suspension and consequential proceeding, my lord, kindly see my prayer. I have challenged everything, a copy of charge also. My lord,
Also-
copy of charge also.
Let's say his submission will be put at rest, page 15. Kindly see the clause. He
1.5.
is liable to be immediately forthwith terminated from the service.
1.5.
1.5.
1.5 or
So the document is start from page 13, intimation regarding his selection in Indian Bank service examination. Page 15, clause G. Kindly see the clause G. The bank has, when bank is liberal enough to give him a so-cause notice. His termination liable to be,
no so-called
service liable to be terminated forthwith.
No so-called.
G.
Clause G.
Canvassing. Canvassing.
Yes, your lordship.
Any form will be. Oh, you are found guilty of impersonation. Bank, you will be terminated forthwith.
Forthwith.
Likhun. The petitioner is an employee of the Indian Bank. Stop. He is aggrieved by the disciplinary proceeding initiated against him on the ground of impersonation. Stop. It has been submitted that the respondent authorities suspended him illegally and arbitrarily. Stop. The provision relating to suspension as suspension prescribed in the Indian Bank Officer Employees apostrophe bracket open discipline and appeal bracket close regulations, 1976 has been relied upon. Stop paragraph. Prayer has been made to set aside the order of suspension and the charges leveled against him. Stop. Learned advocate representing the bank opposes the submission and prayer of the petitioner. Stop. It has been submitted that the petitioner has been found guilty of impersonation. Stop. The Institute of Banking Personnel Selection, who conducted the selection test by which the petitioner got selected, has found that the biometrics taken by the petitioner at the time of appearing in the examination on last two occasions matched the biometric of the petitioner in the present examination where he has been found successful. Stop.
no, my lord.
The petitioner failed to become successful in the earlier two
My lord, possibly that is
entrance examinations.
that examination is not under challenge.
Stop. It has been paragraph. Learned advocate representing the bank relies upon the intimation sent to the petitioner regarding his selection and the pre-joining verification process annexed at pages 13 to 15 of the writ petition, wherein it has been clearly mentioned that if at any stage of selection process / employment, you are found guilty of impersonation or any of the documents are concluded as fake, the service in the bank will be terminated forthwith and will render yourself liable for criminal prosecution. Stop paragraph. It has been submitted that the bank has taken a lenient stand and has issued a show cause notice, and thereafter a regular disciplinary proceeding has been initiated against the petitioner. Stop. Paragraph. Upon hearing the submission made on behalf of both the parties and on perusal of the materials on record, it appears that the charge against the petitioner is impersonation. Stop. The petitioner has already been provided an opportunity to participate in the disciplinary proceeding. Stop. The bank shall take necessary steps to conclude the disciplinary proceeding in accordance with law. Writ petition stands
My lord,
dismissed.
On submission, my lord, in respect of my original service, there is no dispute. 2022 selection, there is no dispute. In respect of present 2025 selection, I further participated. There dispute of. Only, my lord, this is, my lord,
Impersonation proved that she said.
2020 in present recruitment process, 2025 selection.
আচ্ছা একটু ওই জায়গাটা
2022,
বলছিলাম
there is no dispute. my lord.
in an
Where I-
earlier process বললাম না যেখানে ওই জায়গাটা করে দিন যে the petitioner impersonated two other candidates
Yes.
in the selection process
2020 respect.
conducted in the year 2023.
Yes. 20
Yes, RB 23
Maybe, but I have written
2023.
2022. Originally, I
Doesn't
submitted
matter.
2020.
Yes, 2023.
23.
Yes.
23.
Yes, that great.
Oblige, your lordship. With your lordship. Now, slip these. ভুলে যাচ্ছি।
But I'm happy on behalf of a private respondent.
Private respondent. Dismissed. Has the private respondent filed the wakalatnama in the department?
Hey, in this matter, I'm praying for not today. My senior has not come duty in this matter. Kindly keep it on Monday.
What is your name?
HON'BLE.
You are the advocate on
Yes,
record.
ma'am.
Then?
My senior has not come. Only for this accommodation I'm paying.
Why? What is the challenge? You tell me once.
My lord, the petitioners are health assistant under the Department of Health. Now they have, my lord, made a
Transfer.
representation for
All right.
transfer.
The writ petition has been filed by 40 petitioners by depositing only one court fees.
No, my lord, all court fees have been paid.
You filed all court
Yes,
fees? আচ্ছা ঠিক আছে all court fees ঠিক আছে তাহলে এটা লিখুন যে none represents the respondents. Stop, let further notice be issued. Stop, released on 8th of June.
Grateful. This stamp. Yeah, okay. I don't know. 8th of June.
My lord, item number 240, my lord. I'm paying for time, my lord. Today's, my lord. For not today, my lord.
Why?
Because, my lord. No. Sophie Golis. My lord, because service is, my lord, not here with me, my lord, and my lord, state is not represented. My lord, the petitioner is, my lord, praying for
training under the Moitri scheme, which was successor of my lord one scheme which was my lord discontinued in 2014.
Hmm.
Moitri scheme was the successor, and the earlier writ petitions, those writ petitioners who filed that writ petitions, they were my lord allowed to participate in the training under Moitri scheme. But since the petitioner were not in the writ petition, parties were in the not writ petition, my lord, they were not allowed to impart training under the Moitri scheme, my lord. Thereafter, my lord, division bench order has been the petitioners preferred appeal before the division bench, my lord. The division bench, my lord,
Modified the order.
modified the order, my lord.
Yes.
Thereafter, my lord, they applied, but in the page 73, your lordship, kindly see, my lord, annexure P9,
Hmm.
the application was rejected, my lord. Their application was rejected as per the criteria mentioned in the point 3 of the memo dated 11th February 2021, my lord, which is annexed in page 24, 74, my lord.
It has been mentioned that you are not eligible for the Moitri training.
Yes,
You say you are eligible. Is
We
it
are-
your case that you are eligible?
we are eligible under, my lord, Prani Bandhu, my lord, scheme, which
Yes.
was, but since the Moitri scheme was a successor of the, my lord, and the central government scheme was the Prani Bandhu.
The order dated 28th of August 2024, passed by the Chief Executive Officer of Paschim Bongo Go Sampad Bikash সংস্থা, rejecting the petitioner's prayer for participating in the training in the Moitri training, MAITRI, by observing that the petitioners are not eligible for the same, is impugned in the instant writ petition. Stop. The matter cannot be decided in the absence of the respondents. Stop. Let further notice be issued. The respondents are directed to file an affidavit disclosing their stand by 26th June. It will be open for the petitioner to file reply to the same within a period of 2 weeks. Stop. Liberty to mention the matter for hearing. Let this order be communicated to the respondents.
Right, ma'am.
My lord, in item number 241, Autoyukta Sengupta is appearing for petitioner due to some health problems on his hand. Unable to come to court.
You are the advocate on record?
I am not the advocate on record.
Where is the advocate on record?
He is also not present in court due to some personal difficulties. So I am praying to keep the matter after vacation, ma'am.
Accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. Released on 8th.
But I'm not the petitioner.
Lord, I am appearing for the Union of India, madam. Till now, we have not received instruction, madam.
Lord, I have challenged transfer order
Transfer order.
and my rejection of my representation, my lord.
Yes.
Kindly consider, my lord, the petitioner is working as sub-inspector civil. Now, during tenure of from his date of
Under which authority? Sub-inspector.
CRPF.
All right.
Since 2019, he was appointed till 2025. He already transferred thrice. Now, in 2023, he is posted in Central Zonal Headquarters CRPF, that is in Kolkata. In December 2025, his father, my lord, suffered cardiac arrest. He is under treatment. And in May 2025, her daughter is also born, my lord.
So for this reason, my lord, he already made an application before the authority for extension of his posting in Kolkata for 1 year. That is pending. Now, without deciding that, my lord, and now their transfer is made through one application that says system for annual transfer over software. Through this application, he was transferred. He was given 21 choice of posting. He chose 21 places. None of one places he was allotted. He was allotted in a far place. He is originally a resident of Uttar Pradesh. Now he is suffering from twice, both ways, my lord. His prayer for extension.
No, what can be done? You are serving in such an organization where your service is required throughout the country.
Yes.
You are always at the beck and call of the service of the nation. So, what is to be done?
If, my lord, they give me to choose 21 places and none of that is, my lord, allotted to me, then, my
Yes.
lord, this is a futile exercise. And the rejection order, that is also vague, my lord, because nothing.
No question of vagueness. Either they say yes or they say no.
So
There is no question of writing an essay to let you know whether they will allow your prayer or not.
But my application for extension that is pending, they at least could consider that, my lord. So only this count for 1 year, the daughter is only 6 months old.
So what?
That is
There are many other CRPF personnel whose daughter or children or mother or father, they may be their difficulties. This is a very challenging job.
yes, that is.
Then there are so many matters being moved every day before the bench only for getting a job. And now when you get a job, you say, no, I need this posting. Now after the posting is done, I said, no, I'll retire at this point of time. I want this benefit, that benefit. You cannot have all, isn't it? Especially when you are in the CRPF.
Yes, but since 2019 to
I do not know if what is the
already
their
thrice
position.
he has been transferred thrice, my lord.
Very well. Please come. The petitioner is serving in CRPF. He is aggrieved by his prayer rejecting rejecting his, what is this 30 for rejection of the
Rejection of, my lord, his
representation
representation.
against transfer. Stop. It has been submitted that the petitioner has a 1-year-old child, comma, an ailing father to look after at Kolkata. Stop. He is originally from Uttar Pradesh. Stop. The petitioner prays for retaining his service in Kolkata for at least a year. Stop. Learned advocate representing the Union of India is directed to revert with instructions. Stop. Released on 8th of June.
Grateful.
243 I'm for the respondent. I'm for the Union of India.
But the brief fact of the case is that petitioner was appointed under compassion.
Tell me your prayer.
Prayer is disbursement of retirement benefits.
All right. Why are they not disbursing?
Don't know.
You do not know. How many years service you have done?
More than 33 years service.
All right. Let me understand. Yes.
Only the things, my lord, here a peculiar case, my lord.
Hmm.
The petitioner's father, he was an employee of Port Trust as a temporary employee. He was not a permanent employee. Even the temporary employee for disabled, he was discarded from service. So thereafter, my lord, he did not apply for pension because he knows very well he is not entitled to pension.
Father.
After the death of the father, my lord, the wife made an application for pension. Then he filed a writ petition before this honorable court. This honorable court was pleased to direct the authorities to consider his case, whether he is entitled to pension or not. After considering his case, authority has said that she is not entitled to pension because the deceased employee was a temporary in service. That was the order. Challenging that order, my learned friend was very much aware of this writ petition. Thereafter, he filed a third writ petition. Third writ petition was directed to go out of the list because in the meantime, the wife...
It was filed by the widow.
Widow.
All right.
Widow then expired.
All
Then
right.
court said since widow has expired, you take necessary steps. A substitution on that that is pending. They did
All
not
right.
take any steps.
Different issues.
I know,
The petitioner, the
different.
petitioner is in service for
Yes,
33
yes, I'm coming, man. It's a very short point. I'm not saying anything more. What is in the record that will submit. Of that writ petition is pending. My learned friend is aware, but he was not party to that writ
Hmm.
petition. I'm very candid to that. And thereafter, my lord, in that writ petition, we categorically said that he was a temporary employee. A temporary employee cannot ask for a diary in hand.
How did he
Yes,
get
he got
job?
an compensation by false declaration.
Nothing, Lordship.
And he was wait,
Lordship,
and he was in service for
Yes,
33 years,
that
and
is
you
that.
could not detect
That
somebody
is that
made
that, that is a
false
fact. That
representation?
I cannot improve that. That is the fact, man. That is the
Yes.
fact. And thereafter, the so-cause notice was issued prior to filing this writ petition before his retirement.
Uh-huh.
He has given also reply to the so-cause notice. He submitted the documents, and that is under consideration of the authorities, my lord.
Hmm.
This is the present scenario of the case. My lord, what I am saying, my lord, let the matter be posted sometimes, my lord. In the meantime, what decision is come, then I can.
In the disciplinary proceeding.
There is no disciplinary proceeding pending, Lordship.
Wait.
Let me say,
Uh-huh.
disciplinary proceeding. I have not said disciplinary proceeding. I have said a so-cause notice was issued. He has given a reply to the so-cause notice. Thereafter, every matter, all matters have been placed before the authorities to
Alright.
take a decision, my lord. But that is not my written.
All right, but then here also the petitioner has made a representation. You
Only the things.
dispose it off. You consider the representation and dispose it off. So
Very
then
well,
what,
very well, very well, ma'am. Very well, very well, ma'am.
what is the use
Yes,
of
ma'am. Yes,
pending?
ma'am. Yes, ma'am. Very well.
The petitioner prays for grant of pension
Yes.
on his retirement from the Shama Prasad Mukherjee Port, Kolkata, on 31st of October 2024. Stop. According to the petitioner, he was in service for nearly 33 years and he would be entitled to pension. Stop. The submission of the petitioner is opposed by the learned advocate representing the port. Stop. It has been submitted that the petitioner obtained the job by giving false declaration. Stop. A show cause notice has been issued against him, to which the petitioner has replied, stop, the matter is currently pending before the authority. Paragraph. Upon hearing the submission made on behalf of both the parties and on perusal of the materials on record, it appears that a representation from the petitioner is pending consideration at the end of the port seeking releasing of his pensionary benefit. Stop. Paragraph. No useful purpose will be served by keeping the writ petition pending. Stop. Next, in view of the above, the instant writ petition stands disposed of by directing the
Chairman, Lordship.
No, chairman, he cannot, my lord. Only the Shamapra, he has not hired a secretary. Secretary is not the party here.
the financial advisor and
The chief accounts officer is there.
the financial advisor and chief accounts officer of the port being the respondent number 3 herein to take a decision on the petitioner's prayer strictly in accordance with law at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. A reasoned order shall be passed and communicated to the petitioner. Stop. If the claim of the petitioner is accepted by the authority, comma, then necessary consequential steps shall be taken without any further delay. Stop. It is made clear that the court has not entered into the merits of the claim of the petitioner and all points are left open to be decided by the aforesaid respondent at the time of consideration of the petitioner's prayer.
Grateful.
$245 dismissed. $251. Yes. You do not want to press this matter, or you want to press this one?
I want to press this one, my lord. This was,
I am appealing for respondent number 6, my lord.
this is affidavit of service.
Yes, keep it over there.
Affidavit
Yes,
of
ridiculous, ridiculous.
Who is the employer? Eastern Railway.
Railway. Lord, this is a case.
You've served.
I have served. I have served. I have served to all the respondents.
To all the respondents. Union. Did you serve the Ministry of Law and Justice?
What it has been.
You served the respondents directly, I see.
Page number 3 of the affidavit of service.
The Ministry of Law and Justice has not been served.
It has been served, my lord.
Ministry?
Yes, my lord, in the page number 3 itself of my affidavit of service, it has been served. The Union of India through General Manager, Eastern Railway.
The Ministry of Law and Justice. What is your prayer?
My lord.
To conduct de novo inquiry into the complaint of the petitioner.
My lord.
And what is it? Show the inquiry report.
My lord. Inquiry report is, my lord, at page number 46, my lord. It starts from page number 46. I am before your lordship how this inquiry has been biased and what are my grounds.
No, but then in the absence of the employer, it cannot be done. Ajanan appears on behalf of the
My lord, in this,
respondent authorities.
my lord, may I,
Stop. Let further notice be issued. Stop. Released on 8th June.
my lord,
Affidavit of service filed in court is taken
may I
on
comment
record.
one thing, my lord? They have challenged the inquiry report before the read court. This is an inquiry under the POS Act, lordship. And there is a,
Any appeal preferred?
yes, there is a provision of appeal. They have not preferred the appeal.
My lord, I shall.
Next day I'll hear.
My
Let the employer come.
lordship, lordship, may I enter my appeal?
Certainly. Did you file your wakalat?
Yes, ma'am. Yes.
Yes. Dismissed.
8th of June.
8th.
8th of June.
Are you there? For the railways?
For Union of India, my lord.
Union of India, will you be representing the railways also?
No, my lord.
No?
No. Me and Miss says Rashmi Botra, we are representing only Union of India.
No, but the representation of the railways is required. All right, I enter your appearance. Notice will be served in the respondent's office.
My name is fixing on 8th of June.
8th of June.
8th of Item 251, my lord.
Yes, yes. 252. 52 dismissed.
I read by Mr. Devashish Banerjee, behalf of petitioner or CPA for all.
Lord, I am appearing on behalf of PS.
Yes, what is the matter?
My lord, the petitioner participated in a recruitment process in the year 2012. Thereafter, petitioner's
2012?
grievance is that we have finalized the recruitment process. It is already finalized.
When?
Petitioner made 2024. Petitioner made RTI application in the year 2024. It is annexed in, the reply is annexed at page 42.
2012 recruitment process, you all conclude in 2024. You took
No, my lord. No, my lord. It was concluded earlier.
No, lordship. Kindly see the page number 43, lordship.
Yes.
Last reply to query 5 to 9. The information cannot be provided as recruitment process with respected program officers such and such has not yet been concluded.
When did the recruitment conclude? Information and cultural
But
department.
interview, call for interview, the persons who are called for interview, it is annexed in page 42.
42.
In our reply, RTI reply.
This is 25.
Yes,
This is in the year 2025. You say it has been concluded in 24?
No, reply has been sent to the petitioner in 2024.
How does it matter? Is the process over?
I think so far I am instructed the process is over.
When?
Let the report, date was not provided to me. Let a report be filed, report be called for.
Appear in the page number 42, lordship.
What is
Application-
your name? You are Shuchandra Chakraborty.
Yes.
Yes, serial number 1.
Yes, Lordship.
Call
What
for
happened to
interview.
you?
Yes.
Thereafter, no reply has been given. This is second time RTI application, Lordship. Thereafter,
Name an application of 7 candidates who were called for interview. Were you called for interview?
yes, Lordship.
Yes.
You participated and thereafter you do not know your fate.
No, Lordship.
Final result has been published or not?
No, Lordship. Not
No.
even published.
Anja, please come. The writ petition. No, the petitioner participated for recruitment in the post of program officer under the Information and Cultural Department, Government of West Bengal. Published Vide advertisement number 5 within brackets small 1/2011, page 42. Stop. She was called for interview, but thereafter she has not been made aware of her fate. Stop. Paragraph. The petitioner filed a representation before the chairman of the Public Service Commission for immediate finalization of the recruitment process. Stop. The same has not been answered. Stop. The Public Service Commission is directed to file a report by way of affidavit disclosing all facts, figures and documents in respect of the subject recruitment process. Stop. Such affidavit shall be prepared and circulated by 19th June, released on 29th of June. It will be open for the petitioner to file exception to the report prior to the adjourned date.
Affidavit service, Lordship.
Yes, what is your name?
Rakesh Jana, Lordship.
Yes.
I'm for the union, madam.
You for the
Union, madam.
Union of India.
Madam.
256, my lord, I appear for respondent numbers 2, 2, 4, 6 and 7, my lord. But my lord, I am a bit indisposed of due to medical grounds, my lord. I've undergone a foot surgery, my lord. And the second thing, my lord, I would request my learned friends, the petitioner, my lord, to serve a copy of the writ petition, my lord. It's a hard copy has not been supplied, my lord. That's why, my lord, I will be requesting them to supply a copy of the same.
I am for the petitioner. I am led by Shamal sir. He's in another court.
He is in?
Another.
There is a microphone. Raise it up. Yes.
He is in another court, your lordship. I need a short passover.
Short passover, not a long one.
No, short. He's coming.
He is coming. But your learned friend has not got a copy of the writ petition.
We have already.
Any idea about what it is about?
It is about.
My lord, this is the second round of. May I, my lord? I think, my lord, I can help my learned friend. This is the second round of litigation challenging a disciplinary proceeding, my lord, the charge sheet. And now, my lord, in the first round of litigation, their application, their writ petition was disposed of, my lord, without entertaining their prayer for just setting aside the charge sheet, and rather instructing them or directing them, the coordinate bench directed them to file their defense statement within the time as the honorable court decided. Now, thereafter, my lord, because by that time inquiry was concluded, my lord. Now the inquiry officer was waiting for only for their defense statement. That defense statement filed, my lord. Thereafter, my lord, the inquiry officer has submitted his inquiry report. Now, after that inquiry report being served on them along with the necessary documents and asking that, my lord, and asking them to file their reply to that. Instead of filing that reply, my lord, they have come up before your lordship, my lord, once again challenging the this charge sheet and now the inquiry report. This is the crux of the matter, my lord.
So without the defense of the petitioner being put in, you are also not in a position to proceed.
Yes. No.
You are proceeding?
No, my lord, what happened, my lord? No, my lord, what happened? Inquiry proceeding was concluded prior to the first petition filed by them. The inquiry hearing was concluded, my lord, report could not be submitted because they did not file their defense statement. Now,
Yes.
after their defense statement was filed, my lord, they filed their defense statement. The inquiry report was submitted. Now, after the inquiry report was submitted, that was served on the writ petitioner. Now, instead of giving reply to the same, they have filed this instant writ petition
Yes,
once
so
again
without,
challenging the charge sheet.
right, I understand, but then without the reply being filed by the petitioner, you are also not in a position to proceed possibly.
Yes, not. Without the reply being filed, we cannot move any further, my lord. Now they have to file their reply. If my
All right, I
learned
got
friend
it.
now wants to read.
First of all, has a copy of the writ petition been served?
Yes,
Hard copy.
hard copy.
I do not know.
Because the respondents say that he has only received a soft copy and not the hard one.
Possibly his client didn't give him.
See, the copy of the writ petition is quite voluminous.
My lord, yes,
Right.
that's all. It's at my cost. At my cost, my lord.
If it is at your
My
cost,
learned
it is
friend.
at your cost. You request, the petitioner will certainly hand over.
Yes,
That is
yes.
something else. Right?
Yes, at my cost, my lord.
My instructions are a copy of the hard copy was sought to be served on a learned friend, but he refused, directed to file to the
No,
client.
ma'am, let me say, my lord, what my learned senior
Sir,
friend
All
is
right,
saying,
so
my lord.
Client has not
forwarded. All right.
But-
all
but
right.
may
No,
I-
your learned friend is indisposed. He is not in a position to come. He is undergone a surgery.
I'm
Right.
sorry, my lord.
So
My lord, my
he can flex.
difficulty is, my lord, you can keep that aside. This is the convenience brief.
Yes.
This is the only thing relevant. Give to other side. Apni ache?
No, is there any scope for passing any interim order?
Lordship, because
Yes.
Lordship. The whole allegation is that there is a contract. This is regarding POB sand. This is what is on the soil. There are river sand, and in soil there are some portion of sand mixed. So there is a process by which sand from soil, there's overburden over the coal. They are washed and sand is taken out. Now, river sand is expensive. This processed overburden, this is called processed overburden, POB sand. This is cheaper. Now, there is a POB plant.
Who are you?
I am the general manager of a colliery.
All right.
Now, what happened? The POB sand he supplied to, I am not concerned with the payment at all. That is accepted. Somebody, the payment is dealt by financial officers and other persons. Now, their allegation is in the measurement book, it is measured as 15,000 cubic meters, but the contractor has built 1,30,000 cubic meters. I ought to, as a general manager, I ought to have seen. So there are other charged officers also. Now the whole allegation is based on measurement. I have this little of the short comparison. Also take 2-3 pages, my lord. There was a vigilance inquiry. 12 August 24, the first page is that inquiry report. It says, this is to the given by the Chief Vigilance Officer Then to the Chairman of Managing Director. During investigation of one complaint regarding non-payment of supplementary bill of POB, as I said, process overburdens in respect to work order number so-and-so of Kajora area, it is observed that all the running account bills are being processed for payment without the acceptance signature of the measurement book by the contractor in Kajora. So some officers, my lord, I don't want to blame anybody, but they were more interested to take river sand, because if the river sand is taken, river sand contractor gets more money. If POV sand is taken, POV sand. For the company, POV sand is cheaper. I have given the rate. River sand is
100 rupees per cubic meter, and POB sand is 256 rupees per cubic meter. So some officers are interested in taking river sand, my lord, for other reasons. So he say that measurement book, not acceptance signature of the contractor is not taken. It was found that measurement noted in the measurement book is not accepted by the contractor is causing dispute, which is contrary to para 8.2 and 8.3 of the Contract Management Manual 2023. Then he sets out paragraph 8.2. Measurement shall be taken jointly by the engineering charge or his authorized representative and by the contractor or his authorized representative. Para 8.3, before taking measurement of any work, the engineering charge or the person deputed by him for the purpose shall intimate the contractor to attend or to send his representative to attend the measurement. Every measurement thus taken shall be signed and dated by both the parties on the site on completion of the measurement. If the contractor objects to any of the measurements, a note to that effect shall be made in the measurement book, logbook, and signed and dated by both the parties. So signature of contractor is a must in a measurement book. Now, it is hence recommended, the recommendation by the vigilance officer. Next page, ma'am. All area of ECL should be advised that strict adherence of Coal India Limited Contract Management Manual, which is the law for them. Transport contract section 6, so and so general conditions, so and so para 8.2, 8.3 or similar positions of NID, she should adhere to. Administrative action as deemed fit for systematic failure against executives, non-executive of Kajura area, responsible processing and passing of running account bill without acceptance of measurement by contractor in the rock so and so and so. So the vigilance suggested to take steps against executive, non-executives of Kajura area responsible for processing and passing of running account bills without accepted measurement by the measurement by the contractor measurement book. So measurement book is not a authentic document. Now Lordship kindly sees this is the records of hearing. I will very quickly I will place.
What is the court supposed to do here?
Well, whole thing, the whole allegation is, Lordship kindly looks at the allegations straight away. This is page 20 of this compilation is the inquiry report.
Yes.
And at bottom A, Shanta Kumar Chaudhary, charge officer 1, CO1. Now, charges in brief, facts, then evidence, remarks. Allegedly, that my client allegedly failed to examine Mrs. Ahome Consultants Family Contractors second RA bill dated so and so with reference to the entries made in the measurement book, where the vigilance officer says that measurement books cannot be looked into by officials of Pascal East, Pascal West, and Khas Kajara units before approving FC as per Finance Manual Chapter 12, Para 4.3a, resulted in overpayment of 3 crores for excess quantity of 1,30,000 cubic meter of POB. Now, logically turns over the page at page, there's a read petition also page 1143, here page 23, Roman 11, facts. Para 4.03a, Chapter 12, Coal India Limited Finance Manual is not applicable as it pertains to civil engineering works. Sand transport is covered under Chapter 4. So I am charged of not adhering to finance manual, which is not applicable in this case. So how the charges are proved? This is clearly preconceived mind. That initial vigilance inquiry report, no steps were taken on that vigilance report. The concerned persons who were passing bills without taking the signature of contractor, no steps against them. A fresh inquiry started, and I am being made a scapegoat. And
why not you? There are so many with you.
I mean, others also, man.
Then
yes, madam.
Go and participate, and you disclose
I have
your defense.
participated. And not only that, logically sees Not only I participated, I gave them letters. Nashikani sees at page uh, uh, 13 of this company, or page 14. This is January 4. This is an email, page 14, 749 on the right hand side. I write to inquiry officer. I am surprised to receive on 1/12/20 purported report by presenting officer. The said does not include most relevant documents, including reply filed by me, is preconceived and travel beyond charges. Hence, is without jurisdiction.
You disclose your defense over there and.
Lordship, I came. Let me show. Before my time to evidence, please furnish me the following documents. Exit quantity from POB plant. What happens, my lord? Apart from measurement book, when POB sand leaves the plant, there is an exit register. It is entered there. Then when it goes to the bunker, there's a box, cement boxes. From there are underground pipes. Sand is mixed with water and it is transported to void areas where after coal is extracted, that's filled up with sand. Otherwise, it will collapse. So that is called bunkers. It mixed with sand by hydraulic pressure sent to the void area. So I say that exit quantity from POB plant give me, because entry is made in 3 places. Second is bunker.
Whatever you sought for documents, they will provide you, or
they
I
have
do not
not
know.
given. Then I came before court at page 16.
Yes.
Page 16, I came before this court and straight away come to paragraph 12 of the judgment at page 19.
The issue of
I'm grateful.
of documents which will be furnished. They will furnish it to you.
They have not. This is before the inquiry report. In spite of they did not submit. So how do I defend myself if they don't give me the documents?
All right, you want certain documents.
Let them give the documents.
No, my lord.
Sought for.
Yes, my lord. May I now, my lord? If my learned senior friend has finished, my lord, then I
Yes.
will just make my small submission, my lord. I'm grateful to my learned senior friend that he has shown paragraph 12 of the order passed earlier, my lord. My lord, kindly see
Because
once the
the
paragraph
earlier
12.
matter, the court directed rather extended time for filing the defense. Now, if you say
No,
it's already
my
filed,
lord.
all right, and then
My
without the aforesaid documents, you could file the defense.
I could not file. I said it's a preliminary
No.
defense.
All right.
No, my lord, it's wrong. It's wrong, my lord. What my
Otherwise,
learned
both
friend
proceedings violate
submitting,
natural justice.
All
They
right.
took
the order is to be
they passed the inquiry report, and
the
inquiry report does not disclose any offense against me. That is also
my
my
lord.
All right. So
My
let
lord, the
the
earlier order is to be.
proceeding
My lord, they will
conclude.
simply terminate me. It's a whole thing preconceived.
No, my lord, let me just indicate, my lord, my learned senior friend has said, my lord, whatever he has said, most of the
disciplinary authority will take the punishment. Only punishment is remaining.
All right. Yes.
my lord, my
They have
learned
not
friend,
given. They have
learned friend,
said-
senior friend has, he is not allowing. Learned senior friend has said so many things, my lord, most of which are not relevant for this purpose. How the signs are gone, how the signs are blocked, my lord, it's not relevant for this matter, my lord. My lord, kindly see this order of at page 1056, my lord. 1056, 8th volume, my lord. 8th volume. Kindly see it as a whole, my lord. First, my lord.
Is it 19th of January 2020? Is it 19th?
Yes, 19th of January. Yes, my lord. January 2026.
29741 of 2025 WPA?
Yes, my lord. 29741 of 2025.
Yes, please.
Yes, my lord. My lord, paragraph. I'm starting from paragraph 4. In the writ petition initiation, initiation of disciplinary proceedings against the petitioner based on charge sheet dated 25 June 2025 is under challenge. Now, petitioner has prayed for quashing of the said charge sheet dated 25 June 2025. Now, my lord, Mr. Shamol Sarkar, learned senior advocate representing the petitioner, submits in reference to the imputations of misconduct, which is at page 139 of the writ petition, that relevant documents in connection with charges leveled against the petitioner were not supplied to the petitioner during course of inquiry. It's the same thing, my lord, what he has submitted here. It's also submitted that measurement book as referred to the imputation of misconduct is one of the relevant documents which was not supplied in spite of prayer made by the petitioner before the inquiry officer. My lord, I pause here for a moment. Just now my learned friend has said measure book has nothing to do with the measurement book. Nothing can be done, my lord. Here, my lord, it is recorded by the honorable court that my learned senior friend had submitted at that point of time that measurement book is the relevant document which was not supplied to him in spite of prayer made by him. In support of such contentions, my lord, I skip paragraph 6, my lord. 6 and 7, my lord, I skip. Now, my lord, kindly come at paragraph 8. Having heard, please allow me, Mr. Shaka, please allow me.
Yes, please.
Mr. Shaka, please allow me. Having heard the learned advocates representing the parties, it does not appear that during the inquiry proceeding, prayer was made by the petitioner before the inquiry officer to supply documents, including measurement book, as referred to in imputation of misconduct. From the document at page 265 of the writ petition in connection with inquiry proceeding, it appears that one Swarup Kumar De, another charged officer, made a prayer for supply of measurement book entries for the first and second RA bills, but same was denied to the said charged officer. However, from the said document, it does not appear that petitioner made any prayer for supply of measurement book entries. It further appears that Vide email dated 4th January 2026, which is at page 9 of the supplementary affidavit, though petitioner made a prayer for supply of relevant documents, but same was after conclusion of inquiry on 8th November 2025. So inquiry was concluded by that time. Nothing is demonstrated that while responding to the charge sheet dated 25th June 2025, disciplinary authority was requested to supply documents. In view of conclusion of inquiry proceedings on 8th November 2025, at this stage, court is not inclined to interfere with the charge sheet dated 25th June 2025 and the inquiry proceedings. However, petitioner shall be at leave to raise the issue of non-supply of relevant documents while giving reply to the inquiry report, which will be furnished to the petitioner if finding of the inquiry report is adverse to the interest of the petitioner. So, my lord, the petitioner now is to, this order was not challenged, my lord. No appeal was preferred, my lord, by the petitioner. So now, my lord, in view of this order, my lord, so the petitioner now is to first give the reply to the inquiry report, and in his reply, he may take all these points which he wants to, as by dint of the liberty given by the honorable coordinate court, my lord. Instead of the petitioner again has come and again has challenged the charge sheet and the inquiry proceedings as a whole. The inquiry report, not inquiry proceedings. He has not challenged the inquiry proceedings. He has challenged the inquiry report only. Now, my lord, is it the stage, and whether all these things can be done at this preliminary stage without any affidavit at all? My lord, I ask it to myself, my lord.
Correct.
My lord,
So, let him give the report. Let
is
him
dated
reply.
56.
Listen,
But
there
it
is
was
already a
incorrectly
court's
stated
order.
to the court.
There is already a court's order which has not been appealed against. The writ
Of course, in
petition
my
is
favor, why should I?
disposed of. Yes. So you have been given leave to raise the issue of non.
I have raised the issue in my
The
response.
court has already recorded that it will be
Where is
provided
the
if
report?
finding of the inquiry report is adverse to the interest of the
It is
petition.
adverse to me now. The inquiry report after this is adverse to me. Now they should provide me
They
without
have not filed the reply.
proceeding to
They ought
punish
to
me.
have filed the reply.
No,
Sir,
he says that
everything
he
in
has
Tharma is
filed the
injected.
defense. The defense has
No, no,
already
no, 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 no.
filed.
Defense is, my lord, two different things, my lord, kindly, my lord. Defense is another thing, and reply is another thing. Two different things. Defense statement is at the time of inquiry, my lord. Inquiry hearing was concluded, only was waiting for defense statement. The moment defense statement was filed by virtue of this order, my lord, then the inquiry report was made. Now the system of the, as your lordship knows, my lord, what is the procedure in a disciplinary proceeding after the inquiry report is filed, it is served upon the charged officer. So we have served. Now, after it is being served, it's his duty and his obligation to file a reply to it. So, which has been written in paragraph 12, that if he wants to take all these points, yes, if he wants to take the points, these points, let him take in his reply to the
But he
inquiry
cannot
report.
give.
That has
He
not-
will not give the documents on
Well,
which
all things he is taking in
charge.
Why
anticipation,
don't
my
you
lord.
write to them for giving these documents?
How many times
No,
I
my
have
lord, he is to
all
give
of
the
them
reply first.
one
This
document.
order, my lord, of the
Several
honorable
documents I
court
have asked from
cannot
him.
be defied.
And not only in
Now
their
he
order
cannot
sheet
say,
also. Lordship, look at their order sheet.
he cannot say this order. He has not challenged this order.
At page
This order is
4
clear.
of this compilation, Lordship kindly sees. Page 4 of compilation. This is a list of management documents. Lordship sees. item number 7 is measurement book. The whole allegation is on measurement book. The next page, copy of serial number 7 of listed document was not supplied since the quantity 142 point so and so cubic meter is already mentioned second bill. So management document, they have not given copy of the measurement book. Then Lordship kindly sees
He had not applied for.
one of the
1 minute. Copy of the measurement book is serial number 7.
7
And it
says
mentions that it has
not
not
supplied.
since the quantity
Is already mentioned. in the
is
second
already
RB.
mentioned in the secondary bill. So measurement book is only for this purposes regarding the measurement. And this measurement is
That
mentioned.
measurement is accepted, then there will be no charge against me.
If there is no charge, you go and contest.
I'm saying here itself, man, that's why pray that the inquiry report, charge sheet, both should be quashed.
You go before them.
Well, nothing left to go before them. I filed my reply. I filed my.
No, he has not filed reply. He has not filed reply. By
Court
law,
directed
he has
them
not
to
filed his reply.
supply. In spite
He has
of
not
court
filed reply,
order,
my
they
lord.
did
He's
not supply.
he's
Where,
misleading
what
this honorable
else I
court.
can do, my
He's
lord?
misleading. I'm sorry to say, my lord. He's a learned
How
senior
to
member
write
of the bar. He is
repeated
misleading this
letters.
honorable court. Paragraph
Let them
12 of the
suffice
earlier order is.
documents, I'll give my reply.
No, he is to give his reply,
is
and
that?
in reply
Shy.
he can take all these
the
points. No, I am not shy. He is not entitled to
Actually,
whatever
out
he is
of
not
fact.
entitled to. During inquiry proceeding, it's not the documents
Why
on
is
which he
shy
was
to
asked.
give me the documents?
The petitioner,
That cannot be the point, that whether I am shy or not.
the petitioner.
My lord, I filed my reply. After that, they give
No,
me
he has not filed
what
a
I
reply.
do with
Let him
that.
show, my lord, where he has
So
filed his
before
reply.
filing my
Let him
defense,
show.
he should give me the documents.
The petitioner is serving as the, you are the manager.
Manager, general manager.
General
Kajura,
manager of a
Eastern Coalfields Limited.
of a
Kajura
colliery
area,
of
my lord.
Kajura area of Eastern Coalfields Limited. Stop. A disciplinary proceeding has been initiated against him. Stop. Being aggrieved by the initiation of the disciplinary proceeding, the petitioner approached this court in an earlier occasion by filing WPA 29741 of 2025, which stood disposed of on 19th January 2026. The court recorded that the court was not the court was not inclined to interfere with the charge sheet and the inquiry proceeding. The court granted leave to the petitioner to raise the issue of non-supply of relevant documents while giving reply to the inquiry report, which will be furnished to the petitioner if finding of the inquiry report is adverse to the interest to his interest. Paragraph. The court was pleased to extend the time to file the defense statement. Paragraph. Learned advocate for the petitioner submits that the defense statement has already been filed and an inquiry report furnished to the petitioner. Copy of the
documents.
Measurement book sought for by the petitioner.
And other documents, madam.
Measurement book and other documents sought for by the petitioner has, however, not been supplied. It has been submitted that on a perusal of the documents sought for by the petitioner, it will be evident that the entire charges against the petitioner are misfounded and preconceived. Paragraph. Prayer has been made to set aside the entire disciplinary proceeding. The aforesaid submission and prayer of the petitioner is opposed by the learned advocate representing the respondents. It has been submitted that the petitioner has not yet filed his reply to the inquiry report. It has been contended that the petitioner may make necessary submission at the time of filing the reply to the inquiry report. Paragraph. Upon hearing the submission made on behalf of both the parties, it appears that the prayer of the petitioner for interfering with the charge sheet and the inquiry proceeding was not accepted by the court in the earlier occasion when the petitioner filed the writ petition. Stop. The same prayer of the petitioner cannot be re-agitated all over again. Stop. The inquiry report has already been supplied to the petitioner. Stop. It will be open for the petitioner to raise all issues regarding non-supply of relevant documents as already granted by the court on 19th of January 2026. Stop. If a prayer is made by the petitioner, petitioner for supply of documents, the same shall be considered by the authority. Stop. The writ petition stands disposed of.
Only two things.
Great.
Earlier, I have challenged the disciplinary proceedings. This time, I have challenged the inquiry too, so not the same things. Lordship, kindly, while correcting, Lordship,
Earlier also he challenged the inquiry proceeding.
Has been
passed in
submitted that
2026.
the petitioner did not challenge the inquiry
report earlier because it is
in the earlier report,
earlier writ
in the
petition.
earlier writ petition. Stop.
Now,
The same has
I've
been
challenged
challenged
the
in the
inquiry.
present writ petition.
It's a new
Stop.
thing.
It is a fresh cause of action. Yes. All right. Next.
Great, man.
57 my lord, I am for the petition. The petitioner before your lordship, my lord, is a police personnel. He joined his service in 2005, my lord. Thereafter, as a constable, my lord. Thereafter, he got promoted to the my lord, rank of sub-inspector of police. My lord, this writ petition, my lord, we are praying for consideration of 2 leaves which have been, my lord, accepted as extraordinary leave as medical leave, because we have, my lord, a zonal medical board, my lord, recommendation in our favor. My lord, we have submitted several representation which has, my lord, gone unnoticed. My lord, the issue herein is that, my lord, limited to that. But, my lord, after filing of this writ petition, my lord, they have, my lord, taken a disciplinary action against me. So, my lord, we have also, my lord, filed another writ petition. I am praying, my lord, those two, my lord, may be heard.
Give the number.
I am giving, my lord, 10938 of 2026.
10938 of 26. When did you file?
My lord, this was filed on, my lord, this writ petition I filed on 3rd of April, probably.
No, this was filed on 21st of April.
My lord,
and
then 23rd of April, immediately thereafter.
Very well. And it is not there in the list?
23rd of April, I filed, not 23rd of April, we got the, my lord, the disciplinary action notice. Then, my lord, subsequently we filed, but the matter is not in the list, my lord.
10,938 listed নেই?
नहीं तो।
No, it is there only till 10,244. So it went thereafter. Supplementary list কি আছে? আচ্ছা, please come.
My lord, we have
Let
checked
this
both
writ
the-
petition appear along with WPA 10938/2026. 938/2026.
এইবারে? নেই এখনো, লিস্টটা হয়নি। আসেনি এখন, না।
On 8th June.
My lord, I'm
Stop. Let notice be served afresh upon the respondent.
My lord, we filed it on 8th of May.
That is the reason it is not there in the month. All right.
Your Lordship, I am for the petitioner. Advocate on record is suffering from fever. That's why I'm prefer not to do.
Accommodation sought for on behalf of the learned advocate representing the petitioner. Stop. List on 8th June. Stop. Let further notice be served upon the respondents.
I'm for the petition.
I am for the Union of India.
Here the State Bank of India is the answering respondent.
State Bank of India?
That's the notice of it.
Yes.
The petitioner before your lordship is a
Yes, yes, your matter.
261 to.
Hmm.
He is a 100% blind person.
Hmm.
Now, pursuant a recruitment notification issued by the State Bank of India for the post of junior associate, he applied. Now, in the said recruitment process, there was a policy that vacancies were declared the circle wise, the Bengal circle or the UP circle wise. Since the vacancy to the post of the particular post for the blind persons was higher in Bengal, he applied in Bengal. He's originally from UP.
Anybody can apply anywhere.
Anywhere.
All right.
Now he applied, he got the appointment.
Achha.
Pursuant to this appointment and the notification issued, recruitment notification, there is a clause. If you applied for a particular circle or state, after appointment, you cannot seek for a transfer. You will also kindly see that part also first. But kindly see that page 26 is the recruitment notification. Number kindly come to page 27. Number kindly see the left hand column. After just column 8, the above vacancies are provisional and depending on the actual requirement, well, the bold letter is there. There is no provision for inter-circle transfer, inter-test transfer for junior associates to be recruited. Now, I've been recruited. I got appointment. I was posted. I'm now presently posted at Bolpur in a State Bank of India. But after my appointment, I got appointment in 2022. In 2024, I got married a lady who is also 100% blind. Now, after that, we used to reside at Bolpur. Subsequently, that lady got an employment in Delhi in Rammohan Lohia Hospital. Now, we have a child, is it about 6 months. But he's a healthy child, but we both are 100% blind. But I made an application for the authority. Look, this is the situation. My wife got appointment in Delhi. I'm in here. She's with a 6-month-old child. Kindly consider my representation for transfer. But that has been rejected. Now, let's consider the rejection order. Rejection order is at page. May I just page 51.
And that is the challenge.
That is the challenge.
All right.
Kindly see page 50. Like today, I'll pay for your lordship and innocuous payment. Kindly see page 51. And may I read for your lordship? You have joined SBI on 21st February 2022 and currently posted at associate at Bolpur branch, Kolkata circle. You applied for the post of junior associates in West Bengal state as published in recruitment advertisement number so and so. It is clearly stated in the advertisement first and second page in bold letters that there is no provision of inter-circle transfer, interstate transfer for junior associates to be recruited by this advertisement. Also, qualifying candidates who got selected by the above stated recruitment advertisement.
Anyway, they have disclosed that because of the
kindly see the last line, paragraph 5.
bank is having a transfer
Policy for PWBD employee and always have sympathetic approach towards 6 employees. But they have not said that they will not consider my case. Before that, can see another rejection order. There is 2 rejection order. That is page 48. Page 48.
Yes.
Paragraph 4. In this reference, we also wish to apprise that SBI has a well-defined transfer policy for person with disability and has consistently adopted a compassionate approach towards the posting of PWBD employees without any prejudice and discrimination. Hence, any request of yours being within the guidelines will be considered favorably in the near future. But today my prayer before your lordship, let them consider my prayer as per their own guidelines. They have not said that they will not consider my case. They will consider, but in near future, well, kindly consider that one that my wife is 100% blind. She's having a child of 6 months. Now it's about 1 year.
Your wife has already joined Delhi?
Yes, but that is I have annexed.
All right.
Kindly see the particular.
And where is the child?
He is with her
mother
in Delhi.
All right.
Reappointed on 14th May 2025, and child was born on 27th. I'm sorry, 24th September 2025. But this is the issue. But I'm only praying today before your lordship. They have said they have the policy. Let them consider my policy. Apna likhesen page 40.
Well, the clerical cadre transfer is not permissible interstate. Nowhere. We have 2 lakhs employees. And he applied in the advertisement, no advertisement, it was specifically stated also.
He admits that.
Advertisement. Thereafter, my lord, so when he applied, state-wise selection was, he was selected state-wise. There are State Bank, there are 17 circles. One circle is West Bengal, Calcutta circle, which controls Andaman Nicobar and Nepal and West Bengal. So he applied for the state-wise circle. So from one circle to another circle, transfer is prohibited. It is not done in case of clerical error. And that will create administrative imbalances. Here is a genuine case. When he was married, she was not working. He was in the job, then he was married, then he was staying together here.
Anyway, in the change circumstances,
thereafter-
can anything be done? In the change circumstances.
Policy, how would you, my lord?
there
For a
is a
particular
policy,
person,
philosophy
2 lakh
that
employees are
is
there.
Policy one.
Then secondly, my lord, they have applied for disability.
2 lakh employees are not disabled.
No, out of that, my lord, is policy there.
The persons with disabilities, do they have any other guidelines?
That is the guidelines I handed over to you.
What is that?
This is reference is data.
What are they?
State Bank. But kindly see the second page,
Hmm.
starts paragraph 5. No, no, এটা আলাদা guideline. Transfer posting.
Now
of
he has
employees
applied for the
who are
disability
caregiver.
commissioner on this ground. This is going to pass the order on 10th of March, but it was not served. It says no, not possible.
Oh, a further order has been passed.
Disability commissioner, they have suppressed it in the writ petition.
Suppressed.
Suppressed. So therefore, they applied for disability commissioner. That disability commissioner, this is this. They have applied, and the disability commissioner passed the order in the court, but it was not server copy. I could not get it.
Disability commission.
Yes. This was fixed on 3rd. Samran Khan is fixed on 10th March. It was fixed on there. This was the notice I received. We have filed reply. Contest was there. This was the notice. This was a notice I have received. This was notice I have received. Objections were filed. Matters heard, and thereafter, my lord, on 3rd March, order was passed in the open court. It is not permissible, but we couldn't get the server copy.
Oh, you didn't get the server copy?
Yes.
The orders are put up in the server? The orders of the commission are put up in the server?
It was not there. The order was passed in the open court.
No,
Petition was here.
Oh, I understand.
No,
Is
server is not there.
the provision for putting it up in the server is not there, so you have to obtain a
Server,
copy.
this provision, server. It was not given in the server. I think they told me like that it was not, we couldn't get the server copy. We are waiting for that.
From March till May, the server.
There are a lot of cases are pending. Like
Only for putting up in the server? Because order has been, if once order is dictated.
This I am told by yesterday, the order was dictated.
Yes.
Put the parties, but order we have to get the copy of the order. Yet to get the copy.
All right.
And this they approached the disability commissioner. They never told any value.
But I don't have any knowledge for it.
And when it was order was passed in March, they came and filed the writ in the month of April. The writ was filed after that.
Yes, 22nd of April, the writ was filed. If your client is playing the disability card, then it is not proper. Because see, the list of cases, the fact that there was a notice given and it was contested and heard, order passed in March, not mentioned. Your writ petition is liable to be dismissed on the ground of suppression of material fact.
That's true, my lord, but I don't have any knowledge about it.
Yes, that means your client is suppressed.
Yes.
Isn't it?
Ma'am, if you also kindly adjourn for a day so that I can take instruction. This is, your lordship knows, your lordship will find.
No, but then what is the use? You show me that there is any provision under which it can be done.
Yes, my lord, that I have handed over to you.
How can this apply to you?
Yes, my lord, kindly see the rules. The second
Yes.
page, paragraph 5.
Yes.
Transfer posting of employee who are caregiver of differently able dependents.
So you are not the caregiver of.
My wife is 100% blind.
Yes.
Here it says, Lord, kindly see one paragraph. Just I'm reading it for you, Lord.
That is within the circle.
Physically handicapped person employed in our
inter-circle.
bank. Lord, kindly skip over. I'm sure to your Lordship. Kindly see their notification. No, sir, আমি দুটোই করেছি.
See, the moment you apply in terms of a notification and there is a specific bar, how can you rely on separate other rules and say that you should be
And that is also
transferred?
from the reference to interstate, sir. Interstate transfer.
Well, they have not.
If you from
they have-
one
they
place
have-
to other place, it may be some circle. I have
They
not
have
seen
not
that.
rejected my prayer. They have said that your prayer will be considered in near future.
No,
The near future has been done. The near future was 22nd of December and what
It
no.
was further representation. It was further representation.
It
Same
was
thing.
rejected my lord on 26th.
22nd of December, it was mentioned that it will be considered favorably in the near future, and near future is 30th of December. They have rejected your prayer.
30th December was in terms of my representation.
Whatever, so you have
Within
representation.
7 days, my lord, the same thing is like in like
Whatever, if
paragraph
they
5, my lord, kindly see.
if they work fast, you say how could they do it so fast? If they are delayed, you challenge that they are sleeping. Where will they go? Please come.
Kindly
No,
see
sorry, sir.
paragraph 5. Bank
Nothing
is having
doing.
a transfer policy and always have sympathetic approach towards this employee.
This is not one of those posts where transfer is permissible, and that was specified in the recruitment notice. Please come. The petitioner is a sent person blind employee. No, sent person blind person. Stop. Not he. In response to the recruitment notice published by the State Bank of India for recruitment of junior associates, he applied for appointment in the Kolkata circle. Stop. He is originally from Uttar Pradesh.
My lord, one matter is contrary currents.
Please go. Stop. The recruitment notice clearly mentioned in bold letters that there is no provision for inter-circle transfer / interstate transfer for junior associates to be recruited. Stop. The petitioner, accepted the terms and conditions of the accepted the terms and conditions of the recruitment notice and participated in the recruitment process. Stop. He was successful in the same and he got an appointment in the year 2022. Stop. The petitioner thereafter got married to a lady who is also sent percent blind. Stop. The petitioner has been, the couple has been blessed with a baby. Stop. The wife of the petitioner has currently got a job in Delhi and she has shifted over there along with the child who is currently 1 year of age. Stop paragraph. The petitioner submits that he is the sole caregiver of his wife who is a disabled lady. Stop. The petitioner requested for transfer. Stop. The prayer of the petitioner was considered by the bank and by a communication dated 22nd December 2025 was intimated that the recruitment notice clearly mentioned regarding the transfer position of the junior associates to be recruited. Stop. There is no provision for transfer. Stop. It was also mentioned that the bank has a well-defined transfer policy for persons with disabilities and consistently adopted a compassionate approach. Stop. His request would be considered favorably in future. Stop. The request was finally turned down by the bank with a communication dated 30th December 2025, reiterating the provision for transfer as mentioned in the recruitment notice. Stop paragraph. Learned advocate for the petitioner relies on the transfer/posting of employees who are caregiver of disabled dependents.
Clause 4, my lord.
Clause 4. Clause 4.
Yes, my lord. In view of the recent guideline issued by the Government of India, the concession as available to the physically handicapped employee may be made available to the bank employees who is also a caregiver of disabled dependent, that is disabled dependent children and spouse, even though they are not financially dependent. They will have to submit a copy of the physically disabled certificate issued by the designated authority in respect of the
Clause 4. Stop. It has been submitted that a direction may be passed upon the bank to consider his case, relying on the aforesaid guidelines. Stop. Learned advocate representing the bank opposes the prayer and submission of the petitioner. Stop. It has been submitted that the recruitment notice pursuant to which the petitioner applied clearly mentioned in bold letters that there is no provision for inter-circle transfer / interstate transfer for junior associates to be recruited. Stop. It has been submitted that the bank does follow the transfer guidelines in respect of the persons with disabilities, but in respect of this particular post, there is no provision for transfer.
May I submit just only one thing?
Stop. It has been further submitted that
the notification of the central government. I have the
petitioner applied before the court of the chief commissioner for persons with disabilities within bracket Divyangan department, the Department of Empowerment of Persons with Disabilities under the Ministry of Social Justice and Empowerment by filing a complaint being case number DNO/26/CCPD/5773 এই যে এখানে রয়েছে। The complaint filed by the petitioner was heard by the commission, and upon contested hearing, the prayer of the petitioner stood rejected. Stop. Copy of the final order has, however, not been uploaded in the server of the commissioner. Stop. It has been submitted that the petitioner has deliberately suppressed the fact of dismissal of the complaint before the commissioner in March 2026 and filed the instant writ petition in April 2026. Stop. It has been submitted that the writ petition is liable to be dismissed on the ground of suppression of material fact. Paragraph. Upon hearing the submission made on behalf of both the parties and on perusal of the documents placed before this court, it appears that, admittedly, the recruitment notice pursuant to which the petitioner applied for the job clearly disclosed the transfer policy. Stop. It has been mentioned in bold letters that there is no provision for transfer. Stop. Accepting such position, the petitioner participated in the recruitment process and on being successful in the same was recruited in the bank. Stop. There may have been a change in the circumstances of the petitioner, which has caused the petitioner to file an application seeking transfer. Stop. The petitioner, being well aware of the fact that the transfer policy is not applicable in respect of the junior associates, has made the prayer for transfer. Stop. The petitioner also approached before the Commissioner for Persons with Disabilities and on contested hearing lost in the said proceeding to obtain any order. Failed to obtain any order. Stop. Paragraph. As the bank has a specified recruitment policy and guidelines for dealing with prayer for transfer of the persons with disabilities, the bank has applied the same and has found that the prayer of the petitioner cannot be allowed. Stop. The court does not find any error on the part of the bank. Stop. Next, in view of the above, there is no scope for interfering in the instant writ petition. The writ petition fails and is hereby dismissed.
As your lordship pleases. Much obliged.
Tutu. No, I'm for the question. Petitioners before your lordship, the withheld merit listed candidates, my lord, is short for RTI. From the authority, my lord, it has said that the dossier of the petitioner has been sent. But after confirmation, the appointment will be given. My lord. And as of date, my lord, no intimation.
Where is that?
My lord,
dossier has been.
the last page, my lord, kindly comes to my lord, page 46. 47 is the my lord, relevant portions, my lord. Last 3 lines, my lord. Inform the withheld case are required to be further
This is in respect of Payal Mondal. The writ petitioner is.
No, the others is also my lord annexed.
Everybody. How many writ petitioners are there?
Six.
How many court fees have you paid?
My lord, I have paid, my lord. The deficit court fees today itself I have paid, my lord. I can show from my lord.
এই দেখুন তো কতগুলো কোর্ট ফিস দিয়ে।
My lord, I have paid, my lord. I'm showing. Since the
Yes.
last occasion, lord, since my lord, I have paid. Check with them.
Each and everyone has mentioned that the dossier has been sent and appointment will be given. Yeah, what is the stand of the respondents?
Well, you have short for instruction regarding what is the status regarding the complaint and all these things. So if your lordship kindly allows us some more time, we'll come up with the better instructions.
Since verification is a time-consuming process, you may get in touch with the CRPF for further information.
The examination has been over, my lord, in the month of November. My lord. The final merit list was prepared on 15th.
What can be done? It says that it is a time-consuming process.
Time consuming for my lord, so many candidates, my lord,
There are so
suffering, my lord, kindly considers, my lord. Whenever the writ petition has been filed, they are sending the my lord, dossier. In most of the cases, my lord, I have seen, my lord. But after these writ petitions, my lord, that CFSL has cleared the my lord, result, my lord. Otherwise, they are, my lord, it is pending before the CFSL for long time, my lord. We are
It is
losing clearity on all these
CFSL
things, my
Kolkata?
lord. Yes, Kolkata.
Ajay, please come. The petitioner participated for recruitment in CAPF. Stop. Their name has been enlisted in the list of withheld candidates. Stop. The dossier of the petitioner has been forwarded to CFSL Kolkata and other authorities for verification of their candidature. Stop. The same is awaiting. Stop. The petitioner is aggrieved by the same. It has been submitted that the authority ought not to delay in the process of verification. Stop. The petitioners are losing their seniority and valuable years in service. Stop. Prayer has been made to direct the authority to conclude the verification process at the earliest. Stop. From the documents annexed to the writ petition, it appears that the petitioners have been intimated that the process of verification of withheld cases is a time-consuming one. That the process of verification of withheld candidates is a time-consuming one. Stop. Paragraph. The respondents are directed to file a report disclosing its stand, released on 22nd June. Service is taken on record.
Grateful to your lordship.
Can you do it before the 22nd?
Well, it might take some time. Therefore, my lord, if your lordship kindly keeps it on
22nd. Pendency of the writ petition will not stand in the way of the respondents for issuing appointment letter to the petitioner if the verification report, if a proper verification report is available in respect of the petitioners.
Grateful, Your Lordship. Grateful. My lord, so far the deficit court fees, my lord, I am putting this, my lord, the Xerox copy of the, my lord,
All right.
the documents. Which...
Paid. If it is paid, it is paid.
No, I have paid, my lord.
All right, then it is
I
paid.
personally have paid through my mobile.
All right. $264 dismissed.
My lord, in this writ petition, my lord, may I submit to lordship, there is no scope at this stage for having interim order.
All right. Who are you?
I'm for the employer Eastern Coalfields
Eastern
Limited.
Coalfields Limited. What is your prayer?
My prayer, my lord, prayer C, this subsidiary.
For what? Produce documents. What document you want?
Yes, my lord, my submission is this: the father of the petitioner died
Impugned
on.
order of removal shall not be set aside. P4, which page is it?
My lord, page 15.
15.
P4, my lord, page 15, 17.
This is 15th of April 2025, Biplab Baudi. Regarding death information submitted by you against death of late Jiten Baudi, ex-employee. Who is Jiten?
Jiten is my father.
Father of the petitioner, Your Lord.
All right.
But he has been suffered since 18 to 21.
Who? Father?
Father. And he was admitted in the employer's hospital. Thereafter, he was shifted to my lord Ompotent. That is another multi-specialty hospital. Thereafter, my lord, he expired from Asansol SD hospital. Then, my lord, I have paid my application for compulsory appointment. Then they have said that your father was dismissed on 2020.
Obviously, if he has been dismissed in
But
2020,
if my father is admitted in the hospital, then he was not in employment. He
what
was
do
not
you
in.
want to say? He was not in employment. That means he has been dismissed.
That is the dismiss. But the capital punishment issued against him without hearing him. I
That
have
is
no
a different
document.
thing.
I have no document because I am the son. I don't know because I used to look after my father at the hospital. I don't know what document they have provided. Then I made my RTI application. On the basis of RTI application, they issued this.
Yes.
Then, madam, my humble submission is this: two sorts of document is required. First of this, that whether I was admitted in government hospital, in ECL hospital or not.
All right. Now, what the authority has sought to do? They have initiated proceeding against you or what?
initiated proceeding against me. I am the son.
You are the son.
Yes.
Did you get a job also?
No,
No.
they have refused. Because of that,
So what is the writ petition for?
writ petition for compensation appointment. Because what they have stated, that is
Writ
memorandum, they will submit to Lordship.
No, no, let me understand. You pray for compassionate appointment.
Yes.
Has that been considered?
No.
Then why
They said before you're considering the compensation appointment, your father has been removed from the service.
So that means they have considered and rejected your prayer.
That is a challenging of this, my lord. I'm here.
Please come. The order dated 15th of April 2025, passed by the Deputy Manager within bracket HR, Madhopur Colliery, rejecting the prayer of the petitioner for compassionate appointment, is impugned in the instant writ petition. Stop. The respondents are directed to disclose their stand by way of an affidavit by 19th of June. It will be open for the petitioner to file exception to the same within 2 weeks thereafter. Stop. Liberty to mention the matter for hearing on completion of the aforesaid time period. Service is taken on record.
Your Lordship, for habitual absenteeism since 2014, my lord.
In the report, you disclose everything?
I'll disclose all the documents, my lord, also the report of the inquiry. Grateful, Your Lordship.
And please annex how you had communicated it to the employee.
Yes, the employee was present during the inquiry proceedings. Reply to show cause notice.
Very
well
well,
on
very well,
record, my
very well.
lord.
Next.
Great.
Next. Dismissed.
Come page 29.
Yes.
Page 29 is the notification given for appointment of says CSP bank leakage. Kindly turn the next page, page 30.
Who has published this?
It's a video.
Video?
Very short.
Google
I will turn page 30, point number 3.
Yes.
ন্যূনতম শিক্ষাযোগ্যতা প্রার্থীকে অবশ্যই উচ্চ মাধ্যমিক সমমানের পরীক্ষা উত্তীর্ণ হতে হবে। এক্ষেত্রে স্নাতক পরীক্ষায় উত্তীর্ণ প্রার্থী অগ্রাধিকার পাবেন। I am the graduate who has been appointed. He is a HS pass.
You are the graduate and the candidate appointment is higher secondary pass. When was the appointment made?
Appointment made. Page 44 is my representation.
Has it been considered?
No. Page 43 is the appointment, is a list.
How many vacancies are there?
Only one. Only 1%.
Publication of GP list for sale for the post of CSP bank linkage, CSP livelihood under such and such.
Page 43.
Page 43.
9.
You are Shunanda Bishwash.
My name is not there. 9 is Mampi
Potua.
Potua Das. His name is
Gram Panchayat is Loba.
Loba.
You are also from Loba?
Yes, yes. Only this one.
And did you implement the private response?
Yes, yes, yes. It's been delivered. Respondent number 7 delivered.
Aja, please come. The petitioner participated in the recruitment process for the post of CSP-bank linkage and CSP-livelihood under Dubrajpur development block. The recruitment notice mentioned that the minimum eligibility criteria, minimum educational qualification will be higher secondary pass, but the candidates having graduation degree will be given preference. Stop. The block development officer and the chairperson of the block level CAPS CBO-HR committee, page 43, Dubrajpur development block, Birbhum, published a list of selected candidates for the subject post on 27th February 2026. Wherein the name of the private respondent, Mampi Potua within bracket Das, in respect of the Gram Panchayat Loba, LOBA, has been published. The paragraph. Specific allegation of the petitioner is that the said candidate has the qualification of higher secondary pass, whereas the petitioner is a graduate. Step. The petitioner ought to have been given preference over the private respondent who is not a graduate. Step. The petitioner submitted a representation before the block development officer in March 2026 and alleges that the same has not been taken up for consideration till date. Step. The respondents are not represented. Stop. The affidavit of service is on record. Stop. Paragraph. As it appears that the objection filed by the petitioner before the block development officer is pending consideration, no useful purpose will be served by keeping the writ petition pending. Stop. The writ petition stands disposed of by directing the BDO Dubrajpur to take into consideration the petitioner's objection strictly in line with the recruitment notice. After giving reasonable opportunity of hearing to all the necessary parties and by passing a reasoned order. Step. If the allegation of the petitioner is found to be proper, then necessary remedial steps shall be taken by the aforesaid authority. Step. Paragraph. Learned advocate for the petitioner is directed to communicate a copy of the, forward a copy of the subject objection along with all necessary documents to the aforesaid respondent at the time of communicating the order of the court. Step. Paragraph. The writ petition stands disposed of.
Video will pass for a reason order.
Yes, yes. The fate of the objection shall be made known to the petitioner. Yes, yes. 12 weeks. Yes.
As a petitioner and paying for not today.
You are the advocate on record?
No.
No.
Mr. Subroji Chakraborty is advocate on record.
Yes.
Due to his personal reason, he is not available in the court today.
Accommodation sought for 8th June. But the fresh notice to be served upon the respondents.
My lord, I am for the petitioner. My lord, I pray for 1 week's time. My lord, my service is not complete. My lord.
All right, service not complete. List on 8th.
Great.
My lord, 272 service is not complete, my lord, kindly.
It was filed in April and you're not served.
No, my lord, it couldn't be, my lord. My lord, I have already taken steps, my lord, but not complete.
Service not complete. 8th. Yes, next.
My lord, I appear for the private respondent.
Private respondent?
Yes. I have been made.
Dismissed. Don't call any other matter. এরপর দুটোর সময় কি হবে? এরপর adjourn motion? দুটোর সময় হিয়ারিং নেই? দুটোর সময় হিয়ারিং আছে? আচ্ছা।
was under impression that the council appearing for the state, they don't appear. So that I could not anticipate, my lord. It
What
was
you
my
could not anticipate?
2064. It was dismissed for default.
264.
On account of my non-appearance.
So what
Because,
can be done?
I thought they, because none of the council they're appearing.
So
It was my anticipation, and it was my fault that I anticipate something which stands far away from reality.
anyway, you could have kept somebody. 264 restore করে
I'm
দেবেন তো।
extremely grateful.
Five matters, mine, regarding West Bengal Police Constable recruitment, which kept on 18, kind enough, except 18, 20, because of that 18, I have a feeling for that. And another thing is that, on that day when I mentioned, inadvertently, my name goes, Mr. Lahadi's matter, but in 5 matter, this is my matter. Five is mine. And
এই মামলাগুলো বোধহয় 18 তারিখে করা আছে।
this matter is Mr. Lahadi's matter, and I have no connection with Mr. Lahadi, but inadvertently, my name
Your name is recorded,
inadvertently.
and this is also appearing on the 18th.
Might be Mr. Lahadi can.
ওটা দেখুন লেখা আছে along with করা আছে।
Inadvertently recorded here.
All right, maybe দেখি
Kind enough.
এটা কবে
It's
লেখা?
my name.
এটা 18 তারিখ আছে তো?
This five is mine, and I
Since there is an order for listing on the 18th, let it appear on 18th. Let somebody be here. It will be mentioned. I'll adjourn it. All right. I'll post it on the 8th of June.
it will be kind enough, on 20.
Because the respondent will not be appearing. Problem is this.
Matter relating to West Bengal Police Constable recruitment, and there is a vacancy, still there's some vacancies there, if something happened,
No, but then in the absence of the state, it cannot be done.
but if something happened within 20.
আচ্ছা ঠিক আছে 20 তারিখে রেখে দেন। I'll keep it on the 20th, but it will remain in the list on the 18th only.
My junior will be there.
Anybody can stay. It will be mentioned, and I'll do the needful. এইগুলোকে কি mention? Did you mention these matters also?
Yes, this 5 matters already order is there,
ও
So
সব
for
কটাই একসাথে আসার কথা আছে 18 তারিখে দিয়ে দেবেন।
each and every matter, there is a specific direction. The matter will
আচ্ছা
come
ঠিক
out
আছে তাই করুন। 18 তারিখে লিস্টে দিয়ে দিন, নিচে 20th লিখে দিন।
Item number 27.
My lord, I appear for the petitioner. My lord, this is the matter concerning the employees of the High Court Legal Services Committee, the State Legal Services Authority, and all the DLSAs. They're all data entry operators, my lord, who were supposed to get the benefit of a notification of the state government of 2020 and then revised in 2024, where they would get certain security of tenure. Now, in our case, Lordship, what has happened, that benefit has been denied to all such people, even though they are discharging very, very serious duties of public nature, because they control the data entry of all matters concerning legal aid.
And who is denying this benefit?
My lord, the state government. Now, my lord, how this has happened is...
No, but then if the moment you say state government, I'll adjourn it because the state is not represented.
My lord, in that case, without the state lordship, this matter
cannot
can't
be
happen.
done.
Because we won the first time this was rejected. We filed a writ petition. That decision was set aside.
Whatever, the state's
Gotcha.
presence is required. None appears for the state. Stop. The matter cannot be heard and adjudicated in the absence of the state. Stop. Let further notice be issued. Released on 12th June, first Friday after the vacation.
Grateful, Lord. May it retain its position, Lordship. Kindly give some. These people have been suffering for a very long.
Yes, next.
Grateful, grateful. Much obliged.
Hey, Tarina.
In item number 7, I appear for the respondent IOCL Corporation, Your Lordship.
I am for Union of India.
Where
On the
is the
last-
petitioner?
On the last occasion, the petitioner had sought time to file an exception to the report which we had filed, Your Lordship.
Has that been filed?
Yes, Your Lordship. On the last occasion, it has been filed and it has also been served. I have the affidavit of service as well, Your Lordship. Just a second.
Yes. Yes. Who are you? Dipankar Shah.
Panel candidate. And first employment can obtain the fixed certificate. There is a direction to file the report in form of affidavit within 6 May. No copy of the report has been served, madam.
Who is going to prepare this?
So-
Union of India.
Yes.
My lord,
The
the
respondent,
affidavit-
your lordship's order.
Report is ready.
Yes, my lord. It has been affirmed today only, my lord. I
Alright,
am
give.
approaching, but I'm handing a copy to the.
Yes,
I
give.
just received, my lord, going for 1 week time.
Report in the form of affidavit filed by the respondents in court today is taken on record. Stop. A copy of the same has been handed over to the learned advocate for the petitioner in court. Stop. It will be open for the petitioner to file exception to the same prior to the adjourned date released on 8th of June.
Grateful, my lord.
Yes.
Relating to my lord, I have received the exception to the report.
Appointment.
just
May I file the exception?
1 hour back, my lord. I need some
You have received an exception to the report 1 hour back. Yes, go through it.
kindly take up next week. my lord.
May I file?
Exception of the petitioner to the report filed by the Public Service Commission in court today is taken on record.
The exception is filed by me, report filed by the PSC.
Yes. Yes, okay. Stop. Learned advocate for the respondent seeks time to come prepared. Stop. List on 8th.
Reached on, my lord?
8th of June.
8th on, good. But it will be kind enough, my lord, because of that PSC is the respondent. Entry model? Good. There is an entry model. Good.
I'm the respondent. For the petitioner.
Microphone.
Devasis Kundu is for the petitioner, Lordship. Kindly. Not possible, Lordship.
Short passover.
10 and 12, Lordship.
Wait. All right, 10 short passover.
Then, my lord, for the petitioner, my lord, I have received a copy of the report, my lord, just day before yesterday. My lord, kindly give me some time to submit the exception. My lord.
All right. What is the matter about?
My lord, SSC, Staff Selection Commission.
Uh-huh.
My lord, rejected on
CAPF.
PAP.
DME, RME.
DME, RME, madam.
Let me see.
My lord, the ground
My lord, kindly
prediction
see
was
my report, my lord, the first page, my lord.
tachycardia.
Hmm.
My lord,
Tachycardia.
I will show from these records, my lord, that this was not a case that, my lord, I should be rejected, my lord, on the ground of my lord, the medical records. And the review medical board, my lord, did not, my lord, consider, my lord, the guidelines. My lord, kindly allows me, my lord, some time to submit
No,
it.
no, on the basis of the documents already on record, it can be decided.
My lord, the first page, my lord. Second page, my lord. Para number 4.
I want to see the review medical examination report. because
Same, my lord. Everything is there, my lord. Everything is there.
Tachycardia with raised total cholesterol level.
My lord. Kindly come to page 2, my lord, para 4.
Page 2.
Para 4.
Further on the basis of vital recording chart.
But tragedy with pulse rate was above the normal limit with raised total cholesterol, my lord. Thereafter, my lord, kindly come to page 12, my lord. The expert's body, apart from DMA and RME, the conclusion, my lord, that VDL cholesterol, my lord, see there, it's on the higher side, my lord. It's there. Nothing remains.
My lord, kindly takes up only page 11 of the report. My lord, blood pressure, BP, my lord, written just below tachycardia.
Blood pressure is all right.
My lord, 156 by 94, 158 by 96, 100 by 98, 156 by 96.
That is all
My
right.
lord, 100 is normal, my lord. 100 is, my lord, kindly.
That's
My lord,
right.
the lipid profile, my lord, was conducted in a non-fasting mode, my lord. It should have been conducted in a fasting mode. I was not informed. I had taken
Tachycardia
breakfast
with
and thereafter,
raised
my lord,
total cholesterol level.
my lord, thereafter the blood sample was taken, my lord.
Sir,
My lord,
they will
kindly-
be serving CAPF.
My lord,
It cannot be
my
done.
lord, tachycardia
Nothing.
is, my lord, kindly.
No,
Just,
no.
just, my lord, one day
Dismiss.
time, my lord, on
No,
one day, my
nothing.
lord, I will come with an exception because these are
Nothing. Your
medical
exception will not
documents.
serve the purpose. Yes, 12 pass over.
Yes, my lord.
All right. 13.
13 I appear for the petitioner.
What are these? 11 দিয়ে দিয়েছো?
My lord had directed to file a report. And to that we have prepared an exception, my lord. Here is my
11
exception.
রিপোর্টটা কিন্তু রেকর্ডে রাখবেন।
Here is my
11 রিপোর্টটা রেকর্ডে রাখবেন। সেটা রেকর্ড আজকেই ফাইল হয়েছে, এটা রেকর্ড করবেন। Yes, what is it? এটা কোনটা দিলেন?
well, item number 13.
13 দিন।
हम लोग फिर भी अपने रिपोर्ट पे ही हैं।
Yes.
It's with regard to squint, my lord. My lord, the main specific direction my lord had directed it comes to page number 2 of my lord's last order. My lord, there kindly comes to 9 and 10.
Yes.
My lord, nearly 10. To put the issue at rest, the responsible are directed to file a report specifically indicating as to whether the script that was detected in the petitioner in November 2025 could have been developed within a period of 1 year. My lord, main cases I was declared fit on under regarding squint in the previous examination. Then they declared me unfit for squint this time. My lord. So a report has been called for, my lord. Now, in that report, nothing has been stated as to my lord's specific query, my lord. Well, রিপোর্টটা জমা দিয়েছেন আপনারা?
হ্যাঁ।
রিপোর্ট kindly sees the report, my lord. Nothing, not a single line as to whether within 1 year a person can develop squint or not, which was your my lord's specific query, was not answered.
No, but then it appears that the review medical examination was conducted by different review medical board comprising 4 medical officers, including ophthalmologist.
My lord.
Then
Now, my lord.
the court will go beyond the over and above what the doctors
Now
have
I'm
said.
coming to this report, my lord. Kindly sees, my lord, I am being speak by Mr.
Yes.
My lord, kindly come.
The fate will be the same, whether you argue or your senior argues.
My lord, kindly come.
It is only consumption of court's time.
No, my lord, kindly comes to page number 76 of the medical guidelines once, my lord. Oh, my lord, in the report, my lord, kindly comes to annexure, I mean, page, this DME, my lord. My lord, squint has been recorded, my lord.
Yes, squint has been recorded. Divergent squint.
My lord, kindly sees the medical opinion, my lord. At the last page, my lord. Finding squint.
Last page.
Divergent squint. Last page, my lord, before the last page.
Yes, I can find out.
Divergent squint left eye, my lord.
Yes.
Finding no recording, nothing. Now, kindly comes to page 76 of the medical guidelines. I will show how it has to be recorded and whether that has been recorded in that manner, my lord. kindly comes to page 76.
Go and give them a training how it is to be recorded.
They should have recorded in but it has been specified in the medical
Yes, so it's
guidelines.
better you go, give them a training as to how it is to be done.
Well, kindly come, it has to be recorded in that manner. Whether it has been recorded in that manner, kindly sees.
Yes.
Page 76, my lord, 34, ocular muscle balance. My lord. This examination is conducted to detect, my lord is saying to detect
Yes, yes.
heterophoria or latent squint.
Yes.
The detection of heterophoria in a candidate for aviation. My lord. Now, there are four types of squints, my lord. The first one is common, they have stated. My lord, now for testing that squint commonly comes to 35. Two types of tests for heterophoria are carried out. In the first group, the two eyes on dissimilar object, and in the second group, they fix on a common object. Heterophoria for dissimilar object is tested by the following test. Number A, the covered test. Number B, the Maddox test. Now, kind of rod test. My lord, kindly comes to 36 then. My lord. Well, this is the way it has to be, the cover test has to be done, my lord. And my lord,
So they will sit over there, the doctors, they will write first this step was done, second this step was done, third this step was done, and this rejected.
the
All right,
interpretation has to be
I
done.
reject it here and now. No, nothing doing. Sorry.
Kindly sees
PAPF authority has to be extremely fit.
there is a specific way of recording that has to be followed. That is 42.
Yes.
78
You go before the appeal court, get it done. It cannot be done here. No, nothing.
Once, if your lordship is not satisfied, your lordship will dismiss my petition. I'm not saying that. Kindly says clause 42 at page 78 once. This is the specific way in which this has to be done. There is no other way of recording. Page 78, the bottom, there is
Yes.
clause 42. Before that, there are interpretation of the results at 39 on the same page. Thereafter, how it has been done, and 42, I'm reading your lordship. Recording of results, the degree of movement is recorded by letters. If slight or moderate is there, specific indications has to be there. Second and third letters has to indicate something, lateral or medial deviation. Fourth and fifth letters has to show the rate of recovery. And the last two letters will indicate whether left and right. It is not that they have to indicate everything, how the tests are being done. But what are the results of those tests have to be indicated in terms of this guideline. If they do not follow their guidelines, your lordship, then it is not. And moreover, your lordship will kindly see the report, the ophthalmologist opinion. Is in my response submission is worse than what we submit before your lordships to say that the reports of SSKM or any government hospital. If this is a finding which they rely upon, that only there is a squint and there is a divergent squint, on what basis, what tests, whatever has been done, there is nothing.
I do not change my view. Whatever is there is there. Squint, check up, and dismiss. Please keep the exception on record.
Kindly, your lordship specifies my submission.
All right, I'll record. I will record. Liken into একটা line. It has been submitted that the findings of the review medical board has not been recorded in accordance with the guidelines for recruitment medical examination. It has only been recorded that the petitioner suffers from divergent squint stuff. The angles and the degrees required recorded in terms of clause 42 of the guidelines. Very well, next.
They have not complied with your lordship's order and my petition.
Yes, next. 14. Yes. State will be required. None appears for the state. Let further notice be issued 8th of June.
Appearing for the petition.
The responded. The order has been complied and payment has been made to the petitioner in his April salary. incentive has been already paid.
My lord, they are paying the amount of 25,000 without the interest.
My lord, for interest, there is instruction that it is not payable, but instruction is like.
When was the amount due to be paid to him?
In 2021.
2021. And why was it delayed? The reason for the delay? No idea. Why it
My lord,
got delayed?
They are
instruction is with my senior and he's due to personal reason he has not come. So I'm paying that. Next
in
date should be
between
fixed for that.
paying others, but not the petitioner. It is intentional delay.
All right. Did you pay for interest
Yes.
before the authority? No.
No, my lord. After filing the writ petition, they made the payment. After
Yes. But you did not, in your application, in your
sorry, my lord.
In-
After filing the writ petition, they made a
payment.
No, they told petitioner to apply a fresh application, and in that application, I also mentioned the interest amount.
All right, please come. It has been brought to the notice of the court by the learned advocates representing both the parties that the lump sum amount of rupees 25,000 as incentive has been paid to the petitioner. Stop. Learned advocate for the petitioner submits that as the amount has been paid at a delayed point of time, comma, the same should be accompanied by interest. Stop paragraph. Learned advocate for the Union of India submits upon instruction that interest is not payable. Acha, stop. The Union of India, no, the Chief General Manager, comma, Gun and Shell Factory, comma, Kashipur, is directed to intimate the petitioner the fate of his prayer for grant of interest on account of delayed payment of his legitimate dues. Stop. Specific reason for not paying interest shall be mentioned by the aforesaid respondent. Stop. The aforesaid respondent shall communicate the decision within a period of 4 weeks from the date of communication of this order. Writ petition disposed.
My lord, they are deliberately not paid. They paid others the amount. I have
Yes.
copy.
And
In 2020 and 2020.
no, now you've got the money.
Yeah.
But then the
They are
delay.
delaying 5 years, my
All
lord.
right, the authority will let you know as to why it has not been paid, why interest will not be payable, and then you can challenge that.
Okay.
Next.
Look, I'm for the petitioner. My last direction has been given. Lordship, please to pass an order. Page number 2 or para 6. Report has been filed by the respondent by way of affidavit disclosing payment in terms of page 26 of the writ
Has this report been filed?
No report has been filed.
How could they file? Because nobody is there now.
My lord, this is very acute situation, my lord. Body fixation.
Acha. None for the respondents.
My lord,
No, the panel is not there. None for the respondents. Let further notice be issued upon the respondents released on 8th of June. Next.
Item number 17, I'm paying for not today, behalf of Ramakrishna Vishwas. Due to illness, he is not available today.
We have paid the money. You are an employee of NTPC. We have paid the money.
So what is it appearing for? Why is it appearing now? A portion of his gratuity and a portion of his leave salary has not been contributed. All dues, NTPC has paid all dues.
Your Lordship, I'm appearing on behalf of NTPC, respondent number 2 to 4. I'm praying for a passover for the day. Your Lordship, as Mr. Shomo Bajam, the senior advocate, he's already appearing on behalf of another matter for fixed.
Accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stuff. Released on 8th of June.
Subject to Lordship kind approval, can it be on 10th? Subject to Lordship kind approval.
8th is the combined list that will be published. In case you have a difficulty, please mention. I'll adjourn.
Date for deduction.
Yes.
If the counsel appearing for the petitioner could not come to the court today due to medical reason, kindly keep it not today. Today's accommodation only.
Accommodation sought. 8th. Notice to be served upon the respondents. देखिए
My lord, in item number 19, my lord, I am for the petitioner, my lord.
Yes.
Let it be adjourned, my lord. State respondent is the only respondent, my lord.
All right. Accommodation sought for 8th. Fresh notice to be served.
Grateful, my lord.
Lordship may kindly see the last order. Very specific order was passed on the state.
Nothing doing. Nothing doing. Same order 8th. Give fresh notice. 20 and 21 both.
Grateful, man.
My lord, I appear for the respondents.
I am for the petitioner.
My lord, on the previous occasion, your lordship was pleased to direct whether this is to be taken by this honorable court or by the Learned Tribunal.
Yes.
Yes, I have seen, my lord. My instruction is it is to be tried by the tribunal.
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 Armed Forces
Armed
Tribunal.
Forces Tribunal.
So
It is periodically sitting, my lord.
Not on regular basis, but if that is the
According
system,
to the last notification,
it will sit on 18th to
18th
20th.
to 20th for the time being.
Right. You approach the tribunal. Petitioner was serving in the territorial army. Actually, Kunta?
Lordship, kindly grant me that liberty to move
Yes.
that on.
The writ petition has been filed by a member of the Indian Territorial Army.
Two members.
Two members.
Two members of the Territorial Army. Stop. Learned advocate representing the Union of India raises preliminary objection with regard to the maintainability of the writ petition before this court. Stop. Paragraph. The court is of the opinion that the petitioners ought to approach the Armed Forces Tribunal for relief, stop. The writ court sitting in Article 226 of the Constitution of India will not be the proper forum to adjudicate the dispute of the petitioner. Stop. Writ petition stands dismissed. Stop. It will be open for the petitioner to approach the competent forum for remedy in accordance with law if so advised.
No, one thing, in absence of the formation,
No, it will be there from 18th to 20th. Please go. The notification is already out. Yes.
I am appearing for the respondent, my lord, Union of India. Lord, last occasion, my lord, I have to take instruction, my lord, may submit.
My lord, petitioner number 2 and 3 has already been given the appointment letter indicating the joining date of 11 June 2020. I am handing over the copy of the appointment letter.
What about 1?
This 1 and 4.
Oh.
They have not yet been considered.
Their result has been, my lord, revised and they have been declared fit and they have been posted, my department has been allotted for, my lord, CISF. Now that all documents has been sent, now it is just formalities to give them that.
1 and 4.
1 and, my lord, 1 second.
2 and 3 appointment is all
1
right.
and 4, my lord, 1 and 4.
So appointment of all 4 secured.
No, 1 and 4 has not yet been.
Their result has been revised. They has been declared fit. It appeared from page number 6, my lord, paragraph number, serial number 48 to 51, my lord.
Give a copy to him.
I
so
have
that-
already, sir, my lord.
Serial number 48.
48 to 49, my lord. Serial number 50 and 51 belongs to petitioner number 1 and 4.
No, petitioner is Najimul Haq.
Yes, Mr. Nazmul Haq, petitioner number 1, he has been recommended for appointment from the CISF.
Yes.
He has not yet
Fit.
been received the appointment letter.
No, but then he will get because he has already been
declared
declared fit.
Shubho Mondol, he has also been
Fit
recommended for
CISF.
appointment CISF. Let your lordship keep this matter after vacation. In the meantime, if they will receive the appointment letter,
Why
otherwise,
keep it pending? They will give it to you because they have
Malad,
mentioned.
in this way they will delay the matter. If your lordship keep this matter pending, then they only next day they will get the letter. Otherwise, your lordship, I am giving the hot example today. Two copy.
Two different minors, CRPF, CISF. They're doing this.
Otherwise, then I have to come before your lordship by filing contempt application. Well, kindly takes up 2 weeks after vacation. In the meantime, they will come.
Very well, my lord.
They will
When he's insisting, my lord, I leave it to
Kindly
your
fix
lordship, my lord.
At least these are the successful ones. Most of them are unsuccessful. But then they are fit. Please come. Learned advocate representing the Union of India submits the instruction forwarded by the Assistant Commandant within bracket legal for IGP WBS CRPF Kolkata dated 11th May 2026, wherefrom it appears that the petitioner numbers 1 and 4 have been found to be fit and they have been selected for CISF. Stop. It has been submitted that the letter of appointment will be issued in their favor shortly. Stop. Paragraph learned advocate representing the petitioner submits that that appointment letter has already been issued in respect of the petitioner numbers 2 and 3. Stop. Paragraph. Release the matter for further consideration on 22nd of June 2026. Stop. Not 22nd, 18th of June.
18th of June.
Stop. The respondent shall issue appointment letter in favor of the respondent numbers 1 and 4 prior to the adjourned date.
Grateful, madam.
এটা ফেরত দিয়ে দিন, এটা লাগবে না. Keep your appointment letters with you. Go and join.
Malad, item number 12. your lordship.
I'll come just now.
Yes.
24.
Sorry, appear for the petitioner, lordship, this is the matter regarding the expedient requirement, whether it's mandatory or directory. Well, it's passed an order on 24th of April 2023. Well, it kindly takes the order. Item
My lord, I appear for the.
I'm for the Indian opinion.
I appear for the contesting respondents, my lord. I have to. I am
Who's the
supposed
contesting respondent?
to 2 to 5, my 2 to 5, my lord. We are supposed to file a report, my lord.
Paragraph 7.
You are supposed to file a report.
File a report.
Please give. Are you aware?
Well, in terms of your lordship's last order, paragraph 7, there was a direction to explain how a person at the age of 18 can acquire the qualification of graduation and leave apart the requirement of experience. Well, as per the terms of advertisement, they have called upon candidates within the.
What does the report say?
Well, the report says that the requirement of 18 has been kept in mind for extraordinary candidates who have attained the qualification of graduation, rather who have jumped some classes, attained the qualification at the age of.
Is it possible? Does the law provide?
My lord, to be humble enough, my lord, with all humility, I submit that sometimes it happened that people under 16 or 18 has been treated as graduate due to their
I do
extraordinary.
not understand treated as graduate.
They has been given graduate degree, my lord. They have passed
who
graduate
has
degrees. It
given?
is my lord, but if my lord,
Show me examples.
if my lord,
It is the law as on date. Till you attain 16 years, you will not be allowed to sit for the class 10 examination.
If
You
it,
cannot. Even if you double promotion, triple promotion, you cannot. 16.
If it is 16, my lord, then
Yes.
16 plus 2, 18.
18, 12.
Plus 3,
21.
21.
Then how come 18?
My lord, it is, my lord, it has been, my lord, for that, to address that point, my defense is that it has been, the institute is quite old, my lord. It has been our it has been our practice that we, for this post and for to give room for those extraordinary meritorious
There is
persons.
no extraordinary meritorious candidate.
So if that be
all
so,
these all these stories sent somewhere else.
If that be so, my lord, even if my lord, the candidate of the candidates of the petitioner is being considered, my lord, kindly consider his own own certificate at page 46. If that be so, my lord, page 46, my lord, the graduation in the 2021. Now, my lord, her experience certificate shows that from at page from 1st February 2020 to 31st January 2023. Then she was studying a full-time course, which is also against the law. Studying a full-time course and serving a authority, serving some institution, and that too, that work also contractual. And kindly, if my lord kindly takes what are the experiences? It has been a wonderful experience to work with Miss Ananya Bosak. Her expertise in communication and administrative works is truly remarkable. Her skills in computer and MS Work Office were really beneficial for our company. And the requirement of the company is that our requirement is that the keeping of records of the at page 30, my lord. Maintenance of service books, personal files of employees, deal with leave pay, financial promotion, pension, LTC, CEA, or act as a requirement of the institute, my lord. So these are on these consideration has appointment could the cancellation could not be reconsidered. This is our submission, my lord. Later, then I leave it to your lordship, my lord. As you.
May I?
And this work, my lord, 47, this was during lockdown period. The offered position was temporary basis and she was to work from home.
May I?
So this work does not match, this experience does not match the requirement of the job, my lord. This is my all humble submission.
What is impugned?
But the impugned order, your
When the letter was given to you and thereafter it was cancelled.
Without assigning any reason, it was cancelled.
No, it has been mentioned, non-fulfillment of the essential
Well, it kindly comes to page 30. What is the essential eligibility criteria? Well, on the last day, well, I have emphasized on that. Your lordship has returned the finding, well, at paragraph 5.
Listen, if the employer says that the qualification and the experience that you have relied upon is not according to their requirement, the court will force them to appoint
Well,
you.
it may just, well, for my satisfaction. Well, the question is whether at all experience can be pressed for the post of UDC. Well, I've made this submission. Well, I may just come back to
the
page.
authority wants a candidate who has this experience.
Well, that is not mandatory.
It is for them, may not be mandatory if they have a better choice.
Well, even otherwise, well, it kindly comes to the advertisement, whether they have all the ground that they have come up with, whether does it find reflection in the advertisement. Well, it kindly takes.
I do not know what is there, but
well, it is not.
I can see page 75, I can see page 30.
Well, I'm at page 30. Well, kindly sees. Well, my post is upper division clerk. Your lordship will find the second entry from the bottom. Well, it records at the top essential qualification. Well, it is graduation. Apart from that, my experience. Well, it is 3 years of experience having good knowledge of English and computer application for office work. Does it qualify any statement, any nature of work? Well, it does not.
It does.
Well, in the next maintenance. Well, maintenance. Well, office work. The next column is maintenance of service books, personal file of employees, deal with leave, pay fixation, promotion, pension, LTC, and etc. Well, these are all administrative work. they have not restrained that the people from private sector will not be entertained for the purpose of these experiences, Your Lordship. This is,
Has it been mentioned that private sector people will not be entertained?
well, that is not mentioned. My client, my lord, was working in a private setup.
How does it matter? It maybe provided she has these experience.
She has these experiences.
Where is your experience certificate?
My lord,
doesn't
kindly
say so.
comes to page number.
Did the employer reconsider her prayer?
Reconsidered, my lord. Reconsidered and rejected. The report.
Again, the report says it is
Report says
rejected.
that-
You have a better candidate.
Well, I have scored 49 in the skill test out of 50. I am the most meritorious candidate. Well, there is a clause given to reconsider or waive these qualification or experience requirement. Well,
Do you have a better candidate?
Well, kindly give me 5 minutes time, my lord. So that I can come. I can take instruction and come.
He was already in the job, right? And in these hard days of employment, total joblessness, if somebody has been selected and only for these minor things that she doesn't have the essential qualifications and everything, you terminate her, it'll be difficult for her, right? Just see, if you have a better candidate, it is all right. But if you do not have, then you can think of keeping her in service.
My lord, then my lord, kindly, my lord, either give me some time or give me 5 minutes time. I can take back instruction and come back.
And
to that extent, I am not.
How many vacancies are there?
Well, 4 vacancies were there. I am the most meritorious candidate. There were other 3 candidates who were
Appointed.
Appointed.
Check up. I'll adjourn it for the day.
Well,
I am keeping the report on record and I post it next week. If there is no other meritorious candidate apart from the petitioner, better than the petitioner, then you can reconsider her prayer for the job. She is a graduate. She has some experience. You have already appointed her. And now if you want to favor somebody and you throw her out,
No, that is.
then that may not be proper.
That will not be proper. That I cannot concede violate, but out of record, I must say.
Please ensure, use your good offices to check up if something can be done. All right.
My lord, except Monday, my lord, any day.
All right. I'll keep it on Tuesday. Wednesday.
Wednesday.
Let it be on Tuesday.
Or Tuesday.
Tuesday,
Wednesday, my lord.
Wednesday.
Wednesday or Thursday, my lord. Wednesday, I agree. Monday and Tuesday, my lord, kindly excuse me.
Acha.
My lord, may I just indicate?
Yes.
I have not addressed your lordship on the point that they have taken, since my learned friend is going to come up with the instruction. My lord, I may reserve my right, my lord, to make my submission.
Yes.
My lords.
Report by way of affidavit filed by the respondent numbers 2 to 5 in court today is taken on record. Stop paragraph. To allow the learned advocate representing the aforesaid respondents to revert with positive instruction as to whether there is any other candidate possessing better qualification than that of the petitioner. And whether the case of the petitioner can be reconsidered for engagement as she fulfills the eligibility qualification and was already issued an appointment letter in her favor, released the same on 20th, that is Wednesday.
Deeply.
Let it appear at the ballot to be mentioned, because only for the instruction it is coming up.
If the instruction is in the negative, then the court has to hear you.
Some precedence, your lordship, subject to my lord's convenience and my lord.
Let us see. Next.
Grateful, my lords. My lord, affidavit of service on the last day was not.
In the meantime, you can take an exception if you want.
My lord, I shall. May kindly grant me that liberty.
It will be open for the petitioner to file exception to the report prior to the adjourned date, because you never know what
I
his answer
appreciate.
will be.
I've reserved my right, I have not made my submission, but I'll make my
Yes,
submission.
all the court will hear you. If he says yes, fine. If he says no,
I'll make my submission.
then the submissions will continue. The court has to enter into the merits and see what can be done.
I shall, my lord. So grateful, my lord.
Deeply appreciated.
My lord, in item 25, I am appearing for respondents 4 and 6 with Mr. Shishra Banerjee advocate who is appearing online.
All right. Yes.
Well, here I am challenging the order passed by the managing director that benefits that is paid.
At 34. Impugned order is at page 34. My lord, my initial submission is this matter pertains to cooperative service of group 5 of the classification list. Benfish is the West Bengal State Fishermen's Cooperative Federation
It's a
Limited.
cooperative service.
Then his prayer is for appointment in group C.
Well, they treated me group C from
No, whether group C or A,
yes.
thing is Benfish is a cooperative and it will be cooperative
It is the
service.
Apex Cooperative Society for Fishermen in the state.
Learned advocate representing Benfish submits that the matter relates to cooperative service. Stop. Paragraph this bench does not have determination to hear the same. You were released for want of determination and be placed.
Correct the presentation form because they are
Placed before the bench having determination. Stop. Leave granted to the advocate on record of the petitioner to amend the presentation form and the front sheet. Service is taken on record.
Grateful to your lordship.
26. 26, my lord, I am waiting for the petitioner. Let here, as per your lordship's direction, my lord, again I serve the district judge as well as the respondent, my lord, the private respondent.
It is required.
They also receive.
Achanan represents the district judge Paschim Bardhaman. Stop. Let notice be served in the office of the learned legal remembrancer, Government of West Bengal. Released on 8th June. Affidavit of service filed in court is taken on record. Please call the passover matters. এই দুটো passover ছাড়া আর কিছু হবে না কিন্তু। Where did Mr. Kundu go?
He was just here. He just went out. Kindly kick. I don't know. 12, my lord. I'm checking for a adjournment, my lord.
Yes.
I'm not in item number 10, my lord.
Oh, you are not there.
I'm in item number
My lord, the learned advocate, I think, is
Shaunak Ghosh.
yes, 11, bar number 11. He requested me, he will go for the LRTT before the LRTT.
Not today. Not today.
Item number 12.
12.
My lord.
12. Last occasion, your lordship, this matter has been sent before the
Ames Kolani
and thereafter measured and declared fit. Thereafter, your lordships directed to give him a copy and come back with the instruction.
Give a copy to him, let him know what is there. What does it say?
My lord, it says that, my lord, we are going to comprise in another body, my lord, expert body, wherein we will again check, my lord. We seek some time for that.
Kindly
The
take
first
up
page,
this
ma'am.
matter after vacation. In the
Yes.
meantime, they will.
Acha, peruse the report forwarded
But I
by the
think
assistant
there is not requirement. That's because the Supreme Court order also says that
commandant
your lordship
within bracket legal
an independent
for
body found that I have the
IGP
within normal
Eta
limits.
Likanevan dated 14th May 2026, which mentions that the recruitment directorate Vide signal dated 12th May 2026 has requested the medical directorate for detailment of BOO, Board of Officer, having an orthopedic specialist for conducting re-examination of the petitioner.
Re-examinations.
Stuff. The process of constitution/detailment of the Board of Officers is under consideration at the competent level, and some time will be required for completion of the medical re-examination process. Stop. In view of such submission of the authority, hearing of the writ petition stands adjourned till 6th July 2026.
My lord, copy has been provided to the court. My lord, kindly record that.
Yes, yes, I'm recording it.
My lord, one thing more, my lord, apart from this order, my lord, in Biltu Ganguly matter, when a third party opinion was sought to be required by the court, honorable court, my lord, there in Biltu Ganguly, the principle was laid down that in those matters, my lord, an expert from our side must also accompany the candidate to ascertain whether their findings are in concurrence with that, because the parameters
are different. Yes.
Yes, madam, certainly, madam. Oh,